seconds and then start.
Oh, right, okay. Right. Welcome to the Supreme Court of the United Kingdom, where today and tomorrow we're hearing a reference by the Attorney General for Northern Ireland under the Northern Ireland Act. The purpose of the reference is to determine whether a legislative provision enacted by the Northern Ireland Assembly lies within its powers. The proceedings are being defended by the Lord Advocate for Scotland, where similar legislation is under contemplation. And we also have interventions by Justice, which is a human rights charity, and by the Northern Ireland Human Rights Commission. I'm joined by six other members of the court for this hearing, and I'll introduce them in a moment. I'm Lord Reeve, the President of the court, and sitting with me is Lord Kitchen.
Good morning.
Lord Burrows.
Good morning.
Lady Rose.
Good morning.
Lord Lloyd Jones.
Good morning.
The Lord President of the Court of Session, Lord Carlaway. Who I think is muted, and the Lady Chief Justice of Northern Ireland, Dame Siobhan Keegan.
Good morning.
We have unfortunately been delayed in starting this hearing by some technical problems, and I should perhaps explain that we're hearing this case remotely, which is an exceptional procedure, because of problems in our building with the air conditioning's ability, or rather inability, to cope with the current heat wave. We may be able to sit in court again tomorrow, depending on how successful work on the system is today. I think we're ready now to commence the hearing. So I'll invite Mr. McGleenan on behalf of the Attorney General for Northern Ireland to make his submissions.
Thank you, my lord. I appear on behalf of the Attorney General for Northern Ireland with my learned friend, Ms. Laura Curran. This is a reference pursuant to Section 11 of the Northern Ireland Act 1998, which permits the Northern Ireland law officer to refer a provision of a bill to the Supreme Court prior to the Secretary of State submitting it for royal assent. So this bill has been through the Northern Ireland legislative process. We're at the stage where the Secretary of State would submit it for royal assent, but the Attorney General has made this reference pursuant to powers in Section 11 of the 1998 Act. If I could just give you an outline of the topics I intend to cover in these submissions. Firstly, I'm going to address the provisions that are relevant to the Northern Ireland Act and the general jurisprudence that's in play in respect of references of this type. Secondly, I want to look at the background of the impugn provision, the history of the bill, its enactment, and a close textual analysis of the relevant provisions of that Act itself. Thirdly, I'm going to examine the relevant Strasbourg jurisprudence on Articles 11, 10, and to a lesser degree 9, and examine the general principles that are applicable in respect of that. And finally, I want to turn to a series of domestic authorities which have grappled with the applicability of those convention provisions in respect of matters that touch on criminal liability. So those are the four broad areas that I propose to cover in these submissions. And I'll start by consideration of the Northern Ireland Act and the relevant provisions there. And tend to draw some parallels with the Scotland Act in light of the fact that the Lord Advocate is opposing the reference, because some of the relevant jurisprudence deals with earlier references in respect of the Scotland Act. and there are some important differences between the two devolution statutes, which sound on, we say, the approach the court should ultimately take. So the court will find the relevant provisions of the Northern Ireland Act in Volume 2, at tab 27, on the electronic format.
Ms. McLennan, we only have
Very good. I'll use the electronic numbering, and it's 1192 for the relevant sections of the Northern Ireland Act. That's where they commence in that volume. You have, at 1192. 1192 electronic formatting has Section 6 of the Northern Ireland Act, which is the provision in respect of legislative competence. And you'll see 6.1 says a provision of an act is not law if it's outside the legislative competence of the Assembly. And then there are a series of provisions which specify the relevant issues in terms of competence. And again, these are familiar from the Scotland Act provisions, but for present purposes, the relevant provisions are Section 6.2c. So a provision is not law and outside competence if it's incompatible with any of the convention rights. So this is a 6.2c competence reference. The Northern Ireland Act, like the Scotland Act, has certain pre-legislative safeguards in terms of competence. And unfortunately, what's not in the electronic bundle, or indeed in the hard copy, is Section 9 of the Northern Ireland Act. But that is a provision that requires a minister, and it's headed scrutiny by ministers. It requires a minister on foot of a statutory obligation to make a statement in respect of a bill on or before its introduction to the Assembly to the effect that the bill would be within the legislative competence of the Assembly. And that's to be a written statement and published by the minister. Now, there's similar provision in the Scotland Act in Section 33. There are some material differences which may have a bearing on the ultimate analysis. Firstly, the Northern Ireland Act, Section 9, applies only to a minister in charge of a bill. And this legislation was introduced by a private member. So there isn't a statutory requirement for a private member under the Northern Ireland Act to make a statement in respect of legislative competence. There is, however, provision in the Northern Ireland Assembly Standing Orders, Standing Order 30, which requires a private member to make such a statement. But there's nothing in the Act, whereas in Scotland, that's embedded in the legislation itself. Secondly, if one compares Section 33, subsection 2 of the Scotland Act to the Northern Ireland Statute, Section 33, subsection 2 of the Scotland Act requires the presiding officer of the Scottish Parliament to make a decision at or before the introduction of the relevant Scottish bill as to whether or not it is within legislative competence, and to state that decision. And the standing orders in the Scottish Parliament require that that be a written decision. There is no equivalent requirement in the Northern Ireland Act. There's no requirement on the Speaker to make a decision or determination to that effect. And there's no requirement in standing orders that a positive statement be made by the Northern Ireland Speaker in that regard. On the same analogy, the Section 33(2) provision in Scotland, which requires the presiding Speaker to make a statement in respect of competence, also requires that advice be taken from the Scottish law officers. And that can be found in paragraph 3.4 of the Scottish Ministerial Code. There is no equivalent provision in the Northern Ireland statutory scheme, or in the Northern Ireland Standing Orders, or in the Northern Ireland Ministerial Code. These are points of some importance, and these are points which were considered closely by the Supreme Court in the 2021 UNCRC reference, where the court closely considered the impact of these pre-legislative procedural safeguards on the reference process. For present purposes, I'm highlighting because it has a bearing ultimately on some of the points raised by the Lord Advocate, that the Northern Ireland position is different. The pre-legislative scrutiny provisions are more dilute. There is no express obligation on a private member in the statute to make a statement. There is no requirement on the Speaker to make a statement about competence. There's no requirement to seek pre-legislative legal advice from the law officers. There is a requirement, or an option rather, for the Northern Ireland Human Rights Commission, if asked, to give advice on a bill and its competence after it's been introduced, but not before. So we have a different scheme in that regard. And again, we say that that's relevant in terms of the overall approach to thresholds for references. The Lord Advocate raises a point about threshold conditions for an ab ante reference to the Supreme Court in a case involving convention compatibility, competence and proportionality. I'll come back to that in a little more detail, but we observe for now that there's no threshold condition identified in the Northern Ireland Act in respect of a Section 11 reference. And indeed, one would have expected, if Parliament had intended there to be some additional threshold requirement in respect of a proportionality case, for something of that nature to be spelt out, but it's not. Section 11 applies without limit in terms of the reference power. I'll return presently to the question of threshold conditions, but I just make that observation for now. If the court has the Northern Ireland Act provision and turns forward to 1197 electronically, you'll see the relevant Section 11 powers, which permits the Attorney General to refer the question of whether provision of a bill would be within competence. And that's the provision that's in play here. If you look at 1198, you will see the process that follows in the event that a reference is made and the court finds that a provision is outside competence. So 1199 has Section 13.5 of the Northern Ireland Act, which states that standing orders shall provide for an opportunity for the reconsideration of a bill after its passing if and only if the Supreme Court decides that any provision of the bill would not be within the legislative competence of the Assembly. So some points are made about the need for circumspection by the court because of the engagement here with the legislative process. It's important to note what actually happens in the Northern Ireland context in a bill of this nature. Under Section 13.5, standing orders must make provision for the reconsideration of the bill after the court makes a finding of a lack of legislative competence. So it goes back in to the legislative process at the final consideration stage. And at that stage, the Assembly can vote on the remedial amendment, if there is a remedial amendment, addressing the issue of legislative competence. So we don't go back to square one with the bill. It doesn't start again. We go back to the final stage of the legislative process on the discrete issue, in this case, of whether Clause 5.2a requires remedial action. And the Assembly can vote on that point and the matter proceeds from there. So again, it's important to note the actual interaction with the legislative process through a Section 11 reference. Now, I should say, in respect of this bill, it's a fact of life that this bill now stands in a situation where the Assembly mandate, which gave rise to it, has expired. We have a new Assembly elected. That new Assembly has not yet sat because of ongoing political difficulties. So we have no Speaker elected. We do not have a sitting Assembly. But those are circumstantial matters which one hopes will ultimately be resolved. But the statutory process provides for this bill, if the court finds there's a competence problem, to go back in at the final stage of the legislative process for a vote to be taken. And again, we say it's important to bear that in mind when addressing the submissions about the need for reticence in a reference. The vote will see at page 1200, section 14 of the Northern Ireland Act, which makes provision for the Secretary of State to submit bills for royal assent. And you'll see here, again, the role of the Supreme Court is identified at 14.2. It can't be submitted for royal assent while there's a reference made and pending. And it cannot be submitted in unamended form for royal assent in the event that the court finds there is an issue in respect of legislative competence. So those provisions knit together and deal with the circumstances which may or may not arise, of course, in the event the court answers the reference in the way which we contend for. I should also show the court section 83 of the Northern Ireland Act, which is at page 1202. This provision features fairly prominently in the intervener's submission, particularly Justice and also the Human Rights Commission submission. And Section 83 is an interpretive provision in respect of acts of the Assembly. And it has an analogue, not an exactly the same provision, but an analogue in Section 101 of the Scotland Act, which has been the subject of close consideration in the UNCRC reference, to which I will return. But Section 83 makes provision for a reading of a statutory provision in the event that that provision can be read either way. In other words, in a manner that's either within or without legislative competence. Section 83.2 states that the provision shall be read in the way which makes it within that competence or doesn't invalidate it for other reasons. So it's a reading provision. It's sometimes compared, as is Section 101 of the Scotland Act, with Section 3 of the Human Rights Act. But it's a superficial comparison because Section 3 of the Human Rights Act is of a different character and nature. And Section 3 of the Human Rights Act permits a reading of legislation, so far as it's possible to do so, in a manner that gives rise to convention compliance. It's a much more expansive power. It's not confined to a specific provision, and it allows greater latitude for the court, having found incompatibility, to identify a corrective interpretation. Section 83 is important in this case because it's suggested against us that the real answer to a legislative competence problem, proportionality problem in this case, is for the court in a specific case to use the Section 83 mechanism to read the legislation in a way that cures a compatibility problem. What we say is, and we'll come to the provision in a bit of detail, is that Section 52A does not lend itself to an either way reading. It's a provision that cannot be read in a manner that is compatible with the Convention. We also point to the approach this court has taken in the recent UNCRC reference in 2021, where these issues have been the subject of consideration. And if I might direct you to the UNCRC reference, which is at page 1539, volume 3 of the authorities, those who are using the hard copy, at tab 36. This is a recent consideration of these types of issues by the court. And the circumstances were slightly different in that case. The provision in question was one which raised a competence issue, not a convention competence issue, but a different type of competence issue, and is one that had been drafted as a matter of policy in a manner that did not deliberately seek to be within competence. And the policy intent seemed to be to allow the Section 101 Scotland Act process to sand down the provision, or through a process of litigation, have an ultimate outcome that was competent. That was the approach that was taken in that case. And you'll see at paragraph 12 of that judgment, that's page 1545, the court is considering the safeguards that apply in respect of pre-legislative competence consideration. And those are the points that I've been alluding to in respect of the analogous Northern Ireland provisions. So you have here reference to the ministerial statement, the presiding member's statement, the advice from the law officer, and the requirement under the ministerial code for all of that to be cleared in advance. As I've indicated, those safeguards are missing, or if present at all, are in a much more dilute form under the Northern Ireland Act. The judgment of the court considers the use of the Section 101 power from paragraphs 56 onwards, that's page 1556. And you'll see paragraph 60. The provision in question had been drafted as a matter of policy in a way that took no account of questions of limitation based on legislative competence. It was a maximalist approach to drafting. The contention was that the Section 101 provision would be used as a remedial step in order to address those issues. And you'll see that's contended for in the passages from paragraph 65 onwards. You'll see a paragraph 69 parallels drawn with the Section 3 reading approach, and the court construes those provisions in that part of the judgment. In paragraph 71, noting the differences between Section 101 and Section 3 of the Human Rights Act. And again, those passages can be read as being equally applicable to the Northern Ireland Act, Section 83. The court's approach to this issue and the use of the Section 101 power is set out in paragraph 72 and following. And the court was of the view that the Section 101 reading interpretive power could not be used in the way suggested as providing a power to modify legislation. And you'll see there the court sets out reasons for that approach, in particular noting the procedural safeguards that apply in the Act, which would be deprived of their effect if this were the approach to be used. The court notes that if that approach were to be used, then the person introducing the bill, the presiding officer, the member, could be satisfied that provisions were within competence, even when they plainly exceeded competence on their face, by relying on the future application of Section 101(2) by the courts. And the court's observation on that, essentially in paragraph 74 by letter F, was that that approach could not be right. It would render nugatory the pre-enactment safeguards under the Act. The second point the court took in respect of that is set out at paragraph 75, and it's a wider point about the constitutional settlement and indeed the need for legal certainty. Because if this approach of a curative reading under Section 101 of the Scotland Act or Section 83 of the Northern Ireland Act were to be adopted to address questions of legislative competence, then there would be difficulties in terms of legal certainty. And paragraph 76, the court observes that one of the key characteristics of the rule of law is the law be accessible, intelligible, clear and predictable. And the thrust of the analysis seems to be that if we're relying ultimately on a body of interpretation to emerge in order to define or create a corpus of jurisprudence that is competent, then it's very, very difficult for citizens to regulate their behaviour in a manner that's in accordance with the law. So it's a fundamental point about using the Section 101 provision in that way. It also, I think, is implicit, and indeed it's touched on, I think, in parts of this judgment, that the Section 101 or the Section 83 process under the Northern Ireland Act is dependent to a degree on the vicissitudes of litigation. It depends on those who are charged with offences, contesting those offences, which are summary in nature, before the magistrate's court. It depends on the points being argued in a certain way, rulings being given, cases being stated to appellate courts, and judgments ultimately being provided. Those things may or may not happen. And in the interim, if a provision is operating which is actually outside legislative competence and is so on its face, then in this context, you have ongoing breaches of convention rights until such times as the body of law develops in the manner foreseen. So the UNCRC decision, we say, is an important ruling, and it touches on one of the mainstays of the intervention arguments, that really a reference is not appropriate in a case like this, and what we should do is allow the legislation to take its course and be the subject of an interpretive process through the courts. And we say the gravamen of the UNCRC decision is to the contrary effect, and the correct course in a case of this nature is to bring the matter through the Section 11 process before the court now. On a related point, the Lord Advocate has taken a point that the threshold condition for an ab ante challenge, a Section 11 challenge or a Section 33 under the Scotland Act challenge, has a high threshold, and the contention is that it's only in a case where the proportionality problem would give rise to convention compliance difficulty in very many, if not all cases, that the Supreme Court will entertain a reference of this type. And that line of argument is based on an analysis of the Christian Institute decision, which is to be found in the electronic bundle at page 404. So this is another reference, and in 2016 to the Supreme Court, issues of legislative competence are in play, and the passage that's relied upon by the Lord Advocate is the passage found at paragraph 88 of the judgment, electronic page 434. Under the heading, whether the interference is proportionate. Now, the passage in question, and this is the judgment of the court, Lady Hale, Lord Reid, Lord Hodge. The passage in question said, this court has explained that an ab ante challenge to the validity of legislation on the basis of a lack of proportionality faces a high hurdle. If a legislative provision is capable of being operated in a manner which is compatible with convention rights, and it will not give rise to an unjustified interference with articulate rights in all or almost all cases, the legislation itself will not be incompatible with the convention. That's the proposition that's stated. I've already observed that that doesn't have a foundation in the Northern Ireland Act in Section 11, or indeed in the Scottish equivalent. It's a statement that it's been explained elsewhere that there is a high hurdle to be applied, doesn't say precisely what the high hurdle is, but then intimates some sort of empirical test of whether or not the legislation is capable of being operated in that manner in all or almost all cases. What we say is instructive in analysing this point about a high hurdle for an ab ante reference is the approach the Supreme Court took, applying exactly the same paragraph of Christian Institute in the McLaughlin case in 2018. McLaughlin is a Northern Ireland case, but it challenged a provision of primary legislation of UK-wide application. And you'll find it at page 621 in the electronic bundle. So the challenge was to the convention compatibility of a social security provision, which made provision for a widow's payment to be made to those who were married, and the relevant provision was section 39A of the Social Security Contribution and Benefits Northern Ireland Act 1992. There was equivalent provision throughout the United Kingdom. So it was an Article 8 read with Article 14 discrimination case, and the contention was that this provision was not compatible with the convention. Now, there was a judgment by Lady Hale, supported by Lord Kerr, Lady Black, separate judgment by Lord Mance, broadly agreeing with that, and a dissenting judgment by Lord Hodge in this case. And ultimately, the majority found that a declaration of incompatibility should be made. But the significance of it in terms of the threshold conditions that apply can be found at paragraph 42 through to 45. That's page 636 to 637. And the court sketches the factual background to the case. This was a case involving a cohabiting couple who'd lived together for 23 years and had 4 children together. The male partner had died, and the surviving female partner sought a widow's payment. It was denied because of the operation of the legislation. Lady Hale's judgment, paragraph 43, deals with the circumstances and the limitations on the making of the declaration of incompatibility. So you'll see it's set out at the top of page 637. So she acknowledges here that it doesn't follow that the operation of the exclusion of all unmarried couples will always be incompatible. It's not easy to imagine all the possible permutations of parentage which might result in an entitlement to widow's parent allowance. The recent introduction to the household of a child from whom the only surviving spouse is responsible is one example. Whether it be disproportionate to deny the child the benefit of the deceased contribution would be a fact-specific question. But then says, but the test is not that the legislation must operate incompatibly in all or even nearly all cases. It's significant. It's enough that it will inevitably operate incompatibly in a legally significant number of cases. That's the Christian Institute, Lord Advocate, paragraph 88. So what we have here is a threshold condition of sorts being applied on a Section 4 incompatibility application. And the threshold is not that it should be in all or even nearly all cases, but it is something different, and we say lower, significantly lower, in that it's a question of whether or not it will operate incompatibly in a legally significant number of cases. Now, reflecting again on that case, on the widow's payment case, it was plain and accepted that that provision was capable of being operated compatibly in a large number of cases. Many, many cases would involve people who were married and for whom the legislation would impose no impediment. There were a smaller cohort who were cohabitees who wouldn't derive the benefit. But the court, in this case, applying paragraph 88 of Christian Institute, was satisfied that it could make a declaration of incompatibility at that much lower threshold condition. So we say the contention that there is a high hurdle for an ab ante challenge under Section 11 or Section 33 of the Scotland Act must be read consistently with the approach the court would take on a Section 4 declaration of incompatibility case. And if the court would declare legislation to be incompatible in a case where it's a legally significant number of circumstances that give rise to incompatibility, then the court could declare on a reference in the same manner that a provision which was likely to give rise to incompatibility in a legally significant number of cases was not competent. So we say, looking at how the Supreme Court has developed this jurisprudence from 2016 through to 2018, and looking at what the court did in McLaughlin, in reality, we question whether there really is a high hurdle in principle for an ab ante challenge. My Lord Jones has a question.
Mr. McLaughlin, I'm sorry, Mr. McGleenan, could you help me please as to whether this passage of paragraph 43 is part of the ratio decidendi of the case?
Yes, my Lord, it is, because that is the essential hook on which the declaration of incompatibility was ultimately made. So this is critical to the declaration in that case, and that's why it was made, because the defence of the case on behalf of the department I appeared in the case was along the lines that on that aspect the provision was capable of being operated compatibly in a very large number of cases, if not the vast majority. And the court said no, that's not the approach. The approach is, and in this case made a declaration of UK-wide application that the provision was not compatible. So it is part of the ratio, Lord.
Yes, I see. And the three other members of the court concurred with that judgment as well as with Lord Mans. I see. Thank you.
Yes, Lord Hodge didn't dissent on that point. Lord Hodge dissented on the general approach to the manifestly without reasonable foundation test, and whether or not this was a case where we should break step with the Strasbourg jurisprudence. So I read Lord Hodge as not taking issue with that analysis.
Yes. Thank you, Mr. McGleenan.
I see another hand from Lord Burrows.
Yes, can I just be clear as to your submission? Is your submission that there is no difference as to the threshold test as between an ab ante, i.e. a reference question, and a Section 4 declaration of compatibility?
Our submission is that there's no conceptual reason why there should be a difference. And if thresholds are to be applied, and that's a different question, if threshold conditions are to be applied, they should be consistent as between Section 4 Human Rights Act, Section 11 Northern Ireland Act, and Section 33 of the Scotland Act. Given that these are threshold conditions created through a process of judicial interpretation, which don't actually appear in the face of the legislation itself. But we...
The other question I had was the Christian Institute paragraph itself relied on an earlier case, the Crown on the application of Bibby.
Yeah.
Are you going to take to that, or is that not something that that you think we need to look at?
I don't think you need to look at it. I have looked at it. We've examined this in terms of the antecedents of the Christian Institute passage, and it doesn't yield any greater insight as to why that point is being raised. Now, what Christian Institute does say, and the passage begins, it has been explained, I think, I've lost the text for me, but it has been explained that it can only have been explained in BB. But when you read BB, I'm not taking the court to it, but it doesn't yield any greater insights as to why we have a high hurdle in a proportionality case. But from our perspective, having to operate as we do with the rulings the Supreme Court has made and striving for consistency in application, we say the approach of McLaughlin gives a clear steer on how this should be dealt with. I see my Lord Reid's hand.
Well, it's really just to make an observation. I see what's said in McLaughlin, and obviously you're entitled to rely on that. It may be that McLaughlin is really a different type of case from Christian Institute, we were concerned with the sharing of what might be highly confidential information about young people's private lives between, for example, their schools and their GPs, but might not be. And so the view was taken that whether the legislation itself was incompatible with Article 8, had to take account of the frequency with which the legislation might operate in a way which breached Article 8. Whether this would be a rare occurrence or something that would happen fairly routinely. And BB, I think, was a similar kind of case to do with the imposition of requirements to ensure that marriages of people entering the UK on the basis that they were married were genuine arrangements rather than marriages of convenience. McLaughlin is an Article 14 case to do with discrimination on the ground of birth status, distinguishing between people who are born to married parents and people born to unmarried parents. On its face, that's discrimination on what is called a suspect ground, and it has to be. It requires a compelling justification. And I see Lady Hale did refer to Christian Institute in that context, but I would just comment that it is a very different sort of case from Christian Institute itself.
Yes, well, I don't disagree with that. Facts are different, but searching for a principled approach, and faced with the contention that there is a high hurdle to surmount in a challenge of this type, it's cleared from the provision in paragraph 43 that the court was prepared to take the quite significant step of declaring a provision of very momentous impact in financial terms to be incompatible with the convention in circumstances where it could be operated compatibly in a significant number of cases. We have a separate point, I think, about the ab ante challenge issue. And again, it links back to what we've said about the Northern Ireland Act and its differences. When the court was making these points in Christian Institute, looking at the Scottish situation, it had, of course, those different features in it. And those features are absent. The pre-legislative safeguards and protections are absent, or more dilute, as I put it, in the Northern Ireland context. So we are and should be wary of erecting thresholds that close off a Section 11 process, which is a process properly identified by Parliament for consideration of exactly this issue, by erecting hurdles in particular proportionality cases that Parliament itself has not done. There's nothing on the face of the Act, Scotland Act, Northern Ireland Act, Human Rights Act, that carves out a different approach in respect to proportionality competence challenges. And we say we should be cautious about embracing this as a general self-denying principle to be applied by the court in cases of this type. And we say that point is a separate reason why one should treat the Lord Advocate's submission with some circumspection in the Northern Ireland context. But we rely on McLaughlin for the reasons that I've outlined, and the decision there in that case plainly has to be read across with and relies upon paragraph 88, which is the mainstay passage relied upon by the Lord Advocate in this case. Sorry.
Mr. McGleenan, can I just pick up on that? Because in the declaration cases, what you have are factual circumstances. You have live cases, scenarios to adjudicate on, which is somewhat different from an ab ante challenge, which I think is perhaps the point in terms of the stage of adjudication that the Lord Advocate is making. Is that not right? And it has actually influenced, I think, some previous, or at least one previous reference brought to this court by the Attorney General.
Yeah, on a slightly different point though, but whether or not we
Yeah.
had a concrete factual circumstance, that wasn't I don't think that was a Section 11 reference. It might have been a reference of the other type. So it was this is different. What I think I would say about that is both the Section 4 process, the Declaration of Incompatibility process in McLaughlin and similar cases, and the Section 11 reference involve a degree of forecasting about the impact of a particular provision on the community at large, the number of cases that will be generated. And it is difficult to address that with any precision, which is why I think the Court of McLaughlin comes up with a concept, which again is difficult to measure empirically, of a legally significant number of cases. So the court's saying we can declare incompatibility if it has that effect in a legally significant number of cases. I'm not quite clear how that metric is applied in reality, but that's the metric the court has chosen. A similar type of forecasting had to take place in the Section 11 case. And Christian Institute, paragraph 88, doesn't give us the metric. It tells us it's a high hurdle. And we ask the question rhetorically, well, what does that mean? What is the high hurdle? How does one calibrate and assess? That's what this court has to ultimately do. And that's why we search back for something else the court's done. And a metric it has endorsed in the Section 4 context is legally significant. Now, how does that play in the Section 5(2)(a) analysis in this case? I'll come to this in a bit more detail, but I'll lay the point down now. If the McLaughlin line is the line, then we're asking ourselves whether the Section 5(2)(a) provision could operate incompatibly, not in all or almost all cases, but in a legally significant number of cases. And if it could operate incompatibly in a legally significant number of cases, then the threshold is met for the court's consideration. And that's what we say gives a coherence to the Supreme Court's jurisprudence on this topic.
I think all I'm really suggesting is that in McLaughlin, there was a factual background that was easier, obviously, to navigate. There was a picture or a canvas, which is different, I think, from this type of anti-challenge.
Yes, respectfully agree and accept that, Milady.
Yeah.
I'm wondering, going back and forth between paragraph 43 of McLaughlin and paragraph 88 of Christian Institute, I wonder if Lady Hale is accurately stating what was decided in Christian Institute. She's saying it between B and C in McLaughlin, paragraph 43. She says it's enough that it will inevitably operate incompatibly in a legally significant number of cases. See Christian Institute, paragraph 88. Now, when one goes back to Christian Institute, paragraph 88, which is on page 434, what was said there was the end of line 2. If a legislative provision is capable of being operated in a manner which is compatible, in that it will not give rise to an unjustified interference in all or almost all cases, legislation will not be incompatible. Okay. So the test there is to do with all or almost all cases, incompatible in all or almost all cases, which gets glossed in McLaughlin into a legally significant number of cases. And in the previous sentence, Lady Hale disowns the idea that it has to be all or almost all.
Yes, Lord. On that turned the Declaration of Incompatibility. And, well, that's the decision of the court, and that's the principle that was adopted. Now, I see, we see the tension between 88 of Christian Institute and 43. They're not textually mapped across, but on that turned McLaughlin. So I think that probably takes me through my first topic, the general jurisprudence and approach on a Section 11 reference. We say this is an appropriate reference. It's one that's broad. The court shouldn't shut it out on a threshold application of a high hurdle, noting the particular features of the Northern Ireland Act scheme and the absence of procedural safeguards before the bill gets to the end of the legislative process. My second topic relates to the Act itself, the provision that we've brought before the Supreme Court. And here, if I could sketch some context for the court. This bill was generated by the 6th Northern Ireland Assembly. This is the 6th elected devolved Assembly in Northern Ireland. It was elected on the 2nd of March 2017. But because of political disagreements, there's a requirement in the Northern Ireland Act for an executive to be formed within 6 weeks of the election. That didn't take place. There was a requirement by Parliament to intervene on 3 occasions by way of primary legislation in order to extend the life of the 2nd of March 2017 mandate. So Parliament had originally intended that we have an assembly within 6 weeks. What actually happened was an assembly was not formed until January 2020. So for 3 years, we had devolved government. It wasn't suspended. Direct rule was not reintroduced. We had notionally functioning devolution without an executive and without an assembly. In early January 2020, the executive was formed. An assembly was appointed after the election of a speaker, and the mandate started. So the 5-year mandate started after 3 years of hiatus. In that assembly mandate, there was no programme for government. So although the political parties agreed to restore devolution, they did not agree, as they were required to do, a programme for government. So there wasn't an executive programme to carry through the remaining 2 years of the mandate. In that period, from January 2020 through to March 2022, there were 36 executive bills passed by the Northern Ireland Assembly. Again, not programme for government bills, but bills taken forward by individual departments and agreed by the Executive Committee. There were also 9 private members' bills, so there was a proliferation of private members' legislation in this attenuated Assembly session. 25% of the output was by way of private members' legislation. And the fact that a bill is introduced by a private member in the Northern Ireland Assembly is a matter of some consequence. A bill introduced by a private member does not have the support of the executive. It does not have the support of a department in its enactment. A bill introduced by a private member does not have a pre-consultation process conducted by a department, a report on that consultation, a policy paper prepared in advance. It is brought forward simply by the member. This bill, the bill we are considering here, was introduced by a private member on the 13th of September 2021. It was not the subject of departmental sponsorship. As I've said, couldn't have formed part of a programme for government, and it was not the subject of a consultation exercise conducted by the department. The private member herself had conducted a consultation of exercise of sorts in the previous Assembly mandate in 2016 to 2017, but nothing of the type one would expect on a significant piece of legislation. So the bill was introduced on the 13th September 2021. It completed its second stage on the 12th of October 2021. There was a report by the Health Committee on the bill produced on the 27th of January 2022, and that committee heard a limited amount of evidence, and you have the documentation in respect of that. I only intend to open a limited amount of primary documentation in this case, but it's in the core volume of papers at page 207. So this is a report on the bill as originally introduced, and I'll take you to that also in a moment. So this is the only analytical document that emerges from the Northern Ireland Department with responsibility in this area. And it's clear from a reading of this report that the Minister for Health and the Department had significant concerns about the feasibility of the bill and the obligations it placed upon the Department. And I'll just highlight some passages for your note. If you look to paragraphs 80 and following, that's at page 230, you'll see the Department's consideration of the safe access zone, which is the issue that we are concerned about here. And you'll see paragraph 84, the Health Minister expressing concerns about whether the provision in question was actually not already covered by existing statutory schemes under the Protection from Harassment Order, which might provide a more feasible route. In paragraph 86, you'll see he expresses the Department's concern about their responsibilities under this bill in effectively having to determine whether or not a criminal offence had or had not been committed and monitoring the effectiveness of the bill. You'll see concerns expressed that striking the balance between the safety and dignity of protected persons and the right to a private life of those seeking the services was not an appropriate function for the Department of Health, and he didn't consider they had competence in this area. There are similar passages expressing reticence about the bill at paragraphs 144 through to 147, page 242 of the bundle. Point is, as I've said, this is private members' legislation in the cognate area of health. It touches on the responsibilities of the Department of Health, and the Department of Health were expressing significant reservations about the nature of the bill, including the clause that is the subject matter of the reference. So, again, one looks at it from a machinery of government perspective. This did not have the type of support one might expect from Department in this context. The explanatory and financial memorandum to the bill can be found at page 270. And again, that gives the court background. It's a limited document. I'll draw your attention to paragraph 8. That's page 271. A reference to the consultation that was conducted. That was consultation over an 8-week period by the member in 2016-2017, the previous Assembly mandate. She submitted a statement in 2020 asking it to be taken forward as a private member's bill, and that was accepted. At paragraph 17, you'll see her statement in respect of the human rights compliance of the bill. It said that she's satisfied, and that statement is then quoted at paragraph 19, under Standing Order 30 of the Northern Ireland Act. Again, as I've already said, this isn't a requirement of the statute. It's not supported by any law officer analysis. There's no obligation to seek such. Now, this is a statement of opinion by the member that is within legislative competence. The bill, as introduced into the Assembly, the original version, can be found at page 81 of the core volume. And obviously, we're going to be looking at the bill as enacted, but it is instructive to look at it in its original incarnation. The overview sets out paragraph clause 1, 2, that it requires the establishment of safe access zones. These are zones which may have the effect of preventing or impeding access to the premises or influencing, harassing, alarming, or distressing persons accessing premises are criminalised. That's the objective of the bill. You'll note that the protected premises are provided for in Clause 2. Clause 3 identifies what can be protected premises. In addition, these are hospitals, trusts, premises providing primary medical services, or any other premises approved by the department. If you look to page 83 and continuing the same clause, Clause 5, Clause 3, Subclause 5, the department may only make a determination if satisfied it's reasonable to do so. So the bill, as originally introduced by the promoter, had a mechanism whereby the department made a judgment about whether it was reasonable to make a determination that premises should be protected. What you will see is that's actually taken out of the bill at the next stage. So the scope for departmental public authority scrutiny is actually excised as it passed through the legislative process. I'll also highlight
Can I just ask, the report that you showed us of the department, was that commenting on this version of the bill or a later version of the bill?
It was commenting on this version of the bill. The bill was subject of amendment following that report. So it wasn't a report of the department, it was a report of the Health Committee. So the politicians who have responsibility in that area prepared that report with some input from the department, some input from the Northern Ireland Human Rights Commission, and some input from other stakeholders. But that was looking at the original version of the bill. The Clause 6 of the bill is the clause that ultimately becomes 5, which is the subject of the reference. You'll see it in its original form in 6. Again, that doesn't change, but you'll note Clause 6.4. It's a defence for the defendant to show the defendant did not know, had no reasonable way of knowing that the protected person was in a safe access zone. So again, that's another potential mechanism to mitigate the impact of this on individuals. That provision is also excised through the parliamentary process. That's removed from the bill in its final form. Then I draw your attention to Clause 8, which is a detailed procedure for designating a safe access zone. And you'll see here that you have responsibilities on the Northern Ireland Department of Health. So there's a notification process to notify that an operator wants to seek a safe access zone. The department designates it within 8 weeks. They have a role in determining the extent of the zone. So there's an evaluative judgment to be made about how big or small the zone is. There's a requirement of consultation, and the department can vary the zone, so it can change in scope. At 8.5, you'll see provisions made for the department to revoke the designation, where it appears that the operator no longer wishes there to be an access zone. And then there's a requirement for them to publish the extent of the zone in a manner as appears to be appropriate. Now again, when we see the final version of the bill as enacted, this section is heavily amended, and the role of the department is significantly reduced. So the determination of extent, the scope to vary, and the scope to revoke are taken out of the legislative process. And what one sees here is a complete reduction of public authority oversight by the department of the safe access zone process. They are removed effectively from this exercise. You'll also note at Clause 9 of the bill, that's page 85, under the heading Exercise of Functions. In exercising those functions, so extent, variation, revocation, the department must have regard to, amongst other things, the safety and dignity of protected persons, the right to respect for private and family life in Clause 9b, and 9c, the right to manifest religious belief, freedom of assembly and expression set out in Articles 9, 10 and 11 of the Convention, and in particular the right to protest. So a target duty, a have regard duty imposed on the department to have direct consideration of those factors in the evaluative judgments they have to make under the Act. That provision is also removed. That's taken out of the bill. So as is, in fact, the reference to the convention in the interpretation section. So there's no reference to the convention or convention rights on the face of the bill as ultimately enacted. Now, I've said in terms of the chronology, the Health Committee report is 27th of January. The matter comes back for consideration stage in the Assembly on the 2nd of March 2022. And I'll just give you the reference for these Hansard debates. I don't intend to go into the detail of the Hansard records. Some of the interveners seek to do so, but we said it's not that illuminating for the court. But the first stage is at page 88, where it's introduced. The second reading also begins on page 88, and the text of that runs to page 129. The 2nd of March consideration stage is at page 130 of the bundle, and the debate there runs through to page 176. And then the consideration stage is the conclusion of the legislative process. So we have two consideration debates. Significantly, the second final consideration debate, there were proposals made to amend the legislation. In particular, proposals made to amend the clause that's the focus of this reference, clause 5.2a. And the proposal was made that that be amended in order to include reasonable excuse. That have followed from the debate to date. The reasonable excuse amendment was actually supported by the bill proposer, Bailey, who brought the bill forward. But the amendment wasn't moved by Ms. Bailey, it was moved by Mr. Allister, a single member of a political party in the Assembly. He moved the amendment, and in the final analysis, it wasn't supported, notwithstanding the promoters' support for it. It was not voted and supported by the Assembly itself. And the only passage of the Hansard record that I really want to open to the court is to be found at page 177. And I open this as a point partly in response to the Human Rights Commission's submission that there's been a very fulsome legislative deliberation on the merits of this statute and its provision. And what you'll see here is that halfway down that page, reference to the member for North Antrim, tabling amendment number 4 to add a reasonable excuse defence to the offence outlined at clause 5.2. This is the private member, promoter of the bill, speaking. And she sets out her view in respect of that. Her support is qualified. But in the penultimate paragraph on that page, she says, I do not see any issue with including it to give additional reassurance on the operation of the clause. Therefore, I support Mr. Allister's amendment to ensure there's not a strict liability offence. I thank him for his assistance and willingness to work with me to get agreement on how to bring that forward. I no doubt and speak to it in great detail. And over the page, if you look at 178, you'll see the chairperson of the Health Committee, Ms. Gildernew, speaks. She's the chair of the Health Committee who produced the report. And she advised the Health Committee have nothing to say on amendment number 4. They have no position on the amendment. But as Sinn Féin spokesperson, she indicates that she will support the amendments in Claire Bailey, the bill sponsor's name, but will oppose that in Jim Allister's name. So what happens in the Assembly is a political stance is taken in opposition to the stance of the member introducing the amendment. It's not an analysis based on merits necessarily. The view is taken that Mr. Allister's amendment will not be supported, even though the bill promoter herself considers that that's appropriate. And on that basis, the Assembly divides. The vote is 44 to 40 on the clause, and the clause falls. So that's the background to the legislative deliberation on the bill. It reached its final stage and was passed in the dying embers of the Assembly at the end of March 2022. In that process that I've just sketched for the court, going back to the Northern Ireland Act, there is no formal input by the law officer, unlike in Scotland, where the law officer would be involved in the advisory stage as the bill matures through its process. There's nothing of that nature. There is a requirement for, or a facility for the Human Rights Commission to be asked for their opinion formally by the Assembly. They do give their view in the report, but it's not a formal opinion in that regard. So there's no law officer input on this. But we get to the point where the clause is put forward with the proposed amendment, which we say would be a curative for the convention incompatibility point, and it's rejected. And we say the Human Rights Commission submissions and the reliance on the quality of the analysis and legal debate, it has to be read contextually, albeit without the court dwelling too much on the Hansard record. Can we turn then to the bill as enacted? And you'll find that at page 264. So, just looking at it fairly closely, I showed you the original version, which had clause 1, which is a general overview. That's gone. Clause 1 now refers to premises where abortion treatments are carried out and sets out the conditions which require to be satisfied to achieve protected premises status. Clause 1, 2 and 3. Clause 2 makes provision for different types of premises. Those are premises where information, advice or counselling about abortion treatments are provided, and these are also protected premises if conditions 1, 2 and 3 are satisfied. And you'll see conditions here are, as in the original incarnation, it's a hospital, it's a clinic provided by a trust, its premises used to provide primary medical services, or any other premises approved for the purpose of this section by the department. Flag that point because it doesn't necessarily follow that it will be a public authority or a public sector provider who is providing information, advice or counselling service in respect of abortion treatments in Northern Ireland. In fact, in reality, it has in the past been bodies such as Mary Stopes, private sector charitable providers who've taken up this course. That sounds on one of the issues raised by interveners, that the answer to this problem, if it is a problem, is to be reliant upon public authorities to themselves mitigate and calibrate the proportionality balance through their Section 6 Human Rights Act obligations. They won't all be public authorities, is the point we observe in respect of that. If you look to page 265, this is clause 2, subsection 4. One of the issues in safe access zones of this type is whether or not they have a finite duration. And one of the issues in respect of this bill and the clauses is the safe access zones developed here, once created, do not have a terminal date. They don't expire. The condition 3 is the effect that the operator has given notice that they wish the premise to be protected premises, and that notice has not been withdrawn by the operator. So once you achieve protected premises status, and you achieve it by giving notice to the department, who exercise no evaluative judgment whatsoever, that safe access zone persists without temporal limit until the operator withdraws it, without any other interaction. So, and that's in contrast to other similar provisions in other jurisdictions and also in England, where usually there is a sunset clause or temporal limit. There isn't in this scheme. Clause 3 deals with protected persons. And again, something of substance turns on this in the convention analysis ultimately. Protected persons is a person attending protected premises for the purposes of accessing the treatment, information, advice or counselling. So that's the person seeking the service. Someone accompanying that person at the invitation of that person, or someone working in or providing services to the protected premises. Now, I flag that point because one of the issues we have to grapple with is the balance that's struck between Article 8 rights of those who are potentially protected persons and 9, 10 and 11. And there is a question mark as to whether or not each of these categories in Clause 3 actually attracts the protections of Article 8. And the attorney in the reference you'll have seen accepts, and I'll take you to the Dulgari case, which is some learning on this. The attorney accepts that those accessing the treatment, information, advisory, counselling service user will attract the protections of Article 8, but does not necessarily accept that those accompanying them or those who are working in or providing service to those premises attract the same Article 8 protection. And that's important because ultimately balances have to be struck, and if Article 8 rights are not in play, then that is another factor in the balance. And I'll take you to Dulgari, Court of Appeal decision on that point presently. The safe access zone and the nature of it is set out in Clause 4. So it's established for protected premises in accordance with this section. So it consists of the protected premises and the public area outside the protected premises, which lies within 100 metres from each entrance to and exit from those premises. So the geographical scope is set at 100 metres from the perimeter of the protected premises. Now, bearing in mind that the premises can be a hospital, and bearing in mind also that under Clause 9, a premises also includes the land on which a premises are situated, one can readily see that the geographical scope of the safe access zones is potentially very extensive. So an urban hospital and the land on which it's situated, and then a 100-metre buffer zone, actually the safe access zone under the statutory scheme. It can also be extended by a further 150 metres under Clause 4.3. The threshold condition here is simply that the operator is satisfied that the 100-metre zone is not adequate to afford safe access to the premises. Again, no role for the department in exercising any evaluative judgment on request extension. So the geographical scope is potentially wide. What's missing from this legislation, the Dulgari case is an interesting parallel, is any provision at all for a zone for protest. So there is no facility within the perimeter of the safe access zone for protesters to gather in order to make their point. There is nothing here within the safe access zone, in contrast to the provision under the English legislation dealt with in the Dulgari case, where there was provision for protesters to gather within 100 metres of the site. You'll see that the obligation on the department in Clause 4.5 is on receipt of a notice under subsection 3, that's the operator's notice. They amend the entry as required. So again, the department's exercising no evaluative judgment in respect of this. Then we turn to the provision which is the focal point. And while I say it's the focal point, it has to be read contextually with all of the other aspects of this which I'm highlighting as we go through it. The focal point is the offence. So offence in this section means, in respect of D, means a person who's not a protected person. Clause 5.2a is the central provision. It says it's an offence for D, someone who's not a protected person, to do an act in a safe access zone with the intent of, or reckless as to whether, it has the effect of influencing a protected person, whether directly or indirectly. That's the critical provision. And it has to be read then with the tail piece, which is the influence is in connection with the person attending protected premises for a purpose mentioned in section 3. So looking back across the page to 265, that includes not just the service user seeking the treatment, advice, counselling, etc. It includes the accompanying person. It includes staff. It includes persons who are not staff but who are providing services to the protected premises in question. So moving back through the clause, again, you'll see there are a number of concepts here which are wide in their scope. So it's an offence to do an act. Act's not defined in terms of exactly what that is. It can be done with intent, or it can be done being reckless as to its effect. And the effect in question can be influencing someone. And it can be done directly or indirectly. And pausing there, one can reflect on the threshold for criminal liability in this context. The threshold for criminal liability is extremely low. A person who does something in a safe access zone which might have the indirect effect of influencing a protected person in connection with accessing and providing services is in jeopardy of criminal liability. And again, we submit those are concepts which are difficult to apply with appropriate rigour in the criminal context. Now, it had been proposed to add a clause, and this was the amendment that was rejected, without reasonable excuse. And had without reasonable excuse been added, that would have allowed a facility for a court dealing with a criminal prosecution to make judgments about the application of the Article 9, 10 and 11 rights. But in the absence of that, the court's left with the ingredients of this offence itself. The Human Rights Commission say the text of that offence itself strikes a proportionality balance, so that you have within it the Article 9, 10 and 11 balance struck. And we say that's a difficult proposition, because where does one see within the text of that provision facility or capacity for the Article 10, 11 or indeed 9 rights? The Justice approach is slightly different. They say it's not a balance that's struck in the statutory provision. They say the answer to this type of clause is to allow it to run through the criminal courts, use Section 83, use Section 3 of the Human Rights Act, and by dint of litigation, prosecutions and convictions, you'll get a corpus of law that probably gives rise to a convention-compliant reading. And they also say the court can apply the appropriate filter. So Clause 5.2a is the problem from the attorney's perspective. The attorney doesn't take issue with Clause 5.2b or Clause 5.2c. Those provisions are different in character. They refer to preventing or impeding access by a protected person, causing harassment, alarm or distress to that protected person. Again, they're not without difficulty, but the contention is not being made that those provisions are not convention compliant. What we say also is that the behaviours that are sought to be addressed by Clause 5.2a, which are truly problematic, are likely to be caught by 5.2b and c in any event, or by Clause 5.3, recording persons. So we have a provision here in 5.2a with a very low, we say, criminal liability threshold, which is directed, one anticipates, to the types of behaviours that would already be caught by the provisions in 5.2b, c and 5.3. Looking then to the enforcement provisions, you'll see that the police are empowered to...
Just before we get to that, can I just confirm that in relation to subsection 4, that in Northern Ireland is a fine, is level 2 on the standard scale, is that £500?
We'll check that. I don't have it at my fingertips, but
well, you can come back to it later.
It's of that nature, but I'll give you the precise
Thank you.
figure. Sorry, Clause 6, I don't intend to dwell on that, but you'll see enforcement powers by a constable. And again here, there are potential interferences with convention rights short of court conviction. So some of the counter arguments focus on courts and convictions, but there is, and Strasbourg jurisprudence supports this, there is clearly a potential for a chilling effect short of prosecutorial action and conviction if you have enforcement of those clauses, and that particular clause in respect of influencing or indirectly influencing persons seeking services. So there is potential impact short of court or prosecutorial action through the police interventions. Clause 7 This stands to be compared with the original Clause 8, which I showed you. The original Clause 8 had a significant involvement of the department, evaluative judgments on the scope of an area, variation, extent. Those are matters that the department had to engage. That is reduced now to maintaining a record. So the obligation of the department is to maintain a list of premises which are for the time being protected premises with an indication of their extent. There's an obligation to publish it in a manner that brings its attention to the members of the public likely to be affected. So the department's role is significantly reduced, and they process the application by the operator, and then they publish the list. That's the nature of their involvement. Now, I showed you also Clause 9 of the original version, which required on its face the department to have regard to the various convention rights, 8, 9, 10, 11, in their discharge of their functions. That's missing and removed from the bill. So that's gone. And you then have the interpretation section, no longer has reference to the convention at all. That's taken out. And you'll notice in Clause 9.2, a reference to the premises is expansively defined as including a reference to the land on which premises are situated. And that's back to my point on the geographical scope of a safe access zone. Now, pausing there, I'll deal with these more fully in a reply, but one of the lines of argument developed by the Lord Advocate is that if there is a convention compatibility problem here, it can be addressed by the fact that there are public authorities involved. So the public authorities involved, the department, the hospital trusts, will have the capacity using Section 6 of the Human Rights Act to mitigate. Not clear exactly how they do that, but it's suggested that they can do it. One of the suggestions is that the department could form judgments about whether or not protected premises should be on the list, and could, forecasting potential convention problems, decline to include a particular premise is on the list. Problem with that as a curative, and it's set against the facility of this reference to cure the problem. The problem with that as a curative is what it means, in effect, is that you would be setting aside entirely the safe access zone. So the department would, in order to address convention incompatibility, not allow a safe access zone to go on the list. The consequence would be that the Section 8 rights of those service users, the women who want to use these services, identified as protected persons in 3A, would have no protection at all. So you lose not just the balance in terms of the Article 9, 10, 11 rights, you lose the protection of Article 8. So in order to achieve convention compatibility by the public authority disavowing a safe access zone, you lose the very purpose of the statute to provide needed protection for women who want to access these services. So we say that is not an answer to the convention incompatibility problem. It just gives rise to a different breach of convention rights in respect of service users, the very thing the legislation set out to prevent in the first instance. And what the attorney is saying is that's a very, very complicated means of addressing what would be accepted in that analysis as a legislative competence problem. The more direct route is for the matter to be brought to this court and for this court to make its pronouncement. So you'll see each of the interveners, and it's interesting, does not really take issue with our substantive analysis on the convention problem in this case.
Lord Kitchen's had his hand up for some time.
Sorry.
Could I just ask you, please, about how the mechanism for that and how it would work, and whether it is primarily directed to these third-party providers? Are we talking now about Clause 2D? Is that the correct provision?
Well, no, I don't think it is. I think what's proposed is that where hospitals, trusts, or others seek access to the list, the department would, in certain cases, decline using a convention analysis to include them. Bear in mind here that the types of cases under 2.2d, they'll be the private sector operators, so they themselves have no obligations. If they are seeking a zone in circumstance that's obviously going to cause a problem with convention rights, I think it's, sorry, I haven't answered your question correctly. I think you're right. That is the focal point of that analysis. Where a private sector provider seeks inclusion on the list, the department can, notwithstanding the plain text of the statute, say no, because they say they have freestanding obligations, but it's not obligations on the operator. And the problem with the statutory scheme is the statutory scheme operates on elective choice by the operator. The departmental involvement has been reduced to almost nothing. They are a ledger keeper. Lord Burrows.
Yes, following on somewhat similarly from the last question, what is your submission in relation to the question if this bill was to be regarded as convention compliant? Do you then say that there is no role for the various authorities involved, assuming they're public authorities, to apply the Human Rights Act in individual cases? I'm thinking, for example, about Clause 4 and the discretion there as to the size and location of the safe zone. And similarly, in relation to your point about the Department of Health, whether they put them on the list or not, what is your submission in relation to that?
The provisions of the Act are binary in nature, so it doesn't allow for graduated judgments about extent or inclusion in the list. You're on the list or you're not, and that's a matter of choice. If you seek a safe access zone, it has a defined scope in the legislation, and there isn't an obvious facility for a public authority to change that. Now, the only way it can be done is by way of a Section 3 reading, conceptually. The problem we have with the Section 3 reading approach is that it's usually considered to be a gateway concept to a Section 3 reading, that you identify an incompatibility in the first place. So you're correcting an incompatibility. If we're in the position that the court says, or it is said to be compatible, it's not clear how you actually get to a Section 3 reading. The second problem I have with this, it's a conceptual problem that occurs in lots of public law contexts and human rights cases, is the idea that public authorities other than courts and tribunals exercise some sort of freewheeling Section 3 reading rule to read legislation in a way that's contrary to its own face. Now, the source for that is the Supreme Court's judgment in RR. It's a judgment of 2018, I think. And it's frequently cited in the lower tiers of the High Court and Court of Appeal as a contention that there is a freestanding obligation of public authorities, not courts, other public authorities, to conduct a reading. And that is problematic because it's not clear why and how public authorities can themselves form judgments about convention compatibility and then read legislation which is plain on its face in a way that means something that's not inherent in the text itself. And just maybe divert for a second into RR, since my lord asked me that question. RR is tab 77, I think. It. You got it? Yes, tab 66, sorry. It's page 726 of the bundle.
It's the supplementary bundle, is it?
Sorry, supplementary bundle, beg your pardon. So it's supplementary electronic 726.
Yeah.
This is a 2019 Supreme Court decision. And the troublesome passage is found at page 736, paragraph 27. conclusions on the principal issue. So the court here is saying the majority of the Court of Appeal in Carmichael accepted the arguments of Secretary of State. In my view, Lord Justice Leggett was entirely right to accept the arguments of the claimant. There is nothing unconstitutional about a public authority, court or tribunal, disapplying a provision of subordinate legislation which would otherwise result in their acting incompatibility with the Convention right, where it's necessary in order to comply with the Human Rights Act. So the problematic feature of that is the public authority concept. So it's not just a court on a Section 3 reading. This is a freewheeling concept for public authorities to apply, to disapply provisions of subordinate legislation using Section 3. The source of it is on the facing page, paragraph 23 of, that's page 735. Lord Justice Leggett in JT in First Tier Tribunal. You'll see the quotation from him, paragraph 122. Whereas here, provision of subordinate legislation can't be given effect in a way which is compatible with the Convention right, and there's no primary legislation which prevents removal of the incompatibility. The court's duty under Section 6.1 is to treat the provision as having no effect, as to give it effect would be unlawful. The conceptual problem we have with this is Lord Justice Leggett is relied upon as a source for the paragraph 27 point, that it is for a public authority to disapply. But Lord Justice Leggett wasn't speaking about public authorities at large. He was addressing courts and tribunals.
I don't think that point was I mean, speaking as a member of that court, that point wasn't lost on us. But what is said there is said quite deliberately, that the public authorities' obligations under Acts of Parliament take priority over their obligations under subordinate legislation.
Yep.
And if there's an incompatibility between the two, they have to obey the Human Rights Act.
Yes.
And that's the gist of the passage, and that simply follows from the constitutional priority of Acts of Parliament over subordinate legislation.
I say it's troublesome with respect, Lord, because in the types of scenario we're talking about now, and you'll see this RR authority relied upon frequently, the contention is that it's for a public authority well removed from a court, a health service manager, someone who's dealing with the premises in respect of a provision of treatment services, to form judgments about whether or not Clause 5.2a of this bill, if it's enacted as an act, is compatible with the Convention, and if not, to read it in a way that makes it compatible. And that's a very significant challenge. And we say it's a difficult means of achieving Convention compatibility. And I suppose it comes to a slightly different submission. Again, goes back to why are we having a reference? We're saying, rather than relying on that to achieve a curative, the Section 11 reference is the correct way forward. And in any event, you only get into this type of reading if you're satisfied that there's an incompatibility in the first place. So the first premise essentially makes our case. It doesn't arise in that context. So there's a slight diversion in response to Lord Burroughs' question. So our submission is, in respect of Clause 5.2a, that it has clearly on its face not struck the proportionality balance. So it's not a provision that in itself contains a proper balance in respect of the Article 9, 10 and 11 rights. It's also importantly a provision that has not got a reasonable excuse provision, which is the other means by which proportionality is satisfied. It stands alone. So if the ingredients of the offence are made out, then the conviction should follow. Now that will, I'll come to a further line of troubling authority on this point, and there are two strands of it, and they link into Ziegler in due course. But on its face, it's important to note that 5.2a is of a particular character. No reasonable excuse offence in it, and we say doesn't strike the proportionality balance in itself. So that's, we say, important to the next stage of the analysis.
Mr. McGlynn, can I ask you on that, just to be clear in my own mind? You've already said the 5.2a in your submission is too wide because arguably Article 8 is not engaged for some of the class of protected persons, right? I think. Yeah. So that's one element. So can you just, if you don't mind, crystallise what you say vis-a-vis why the balance isn't struck as regards the service users who clearly have Article 8 rights?
Yes. So just to be clear, our submission is that the Article 8 rights are not engaged for the Section 3, Clause 3, categories B and C.
Yeah.
They are engaged for A, so the service users. However, we say on its face and read contextually with the geographical scope, the absence of temporal limit, the complete absence of any facility for a designated area for protest, the provision which allows for criminal liability based on nebulous concepts of indirectly influencing someone, makes absolutely no provision for the Article 10 and 11 rights, and of less importance, the Article 9 rights. So on its face, we say there's nothing there that makes provision. And read in context, there's nothing that allows for those rights to be discharged. So this is one of those cases where, and they may be infrequent, where this court can look at a statute provision without facts and applying the McLaughlin threshold or not, something less than that, and come to a view that here we have a competence problem with this provision.
I think, just sorry to follow up as well, you're saying that the rights of service users, the Article 8 rights, I think in your previous submission you said the protection there for them is encompassed within 5(2)(b) and C in any event, which is another part of your argument.
Yes, 5(2)(b) and C, we say will capture the types of objectionable behaviours, and we don't suggest they're not objectionable, that impact on service users. So the bill that deals with those, and the balance is different in respect of those matters. So it's 5(2)(a), that's the offending provision.
Yep.
But of course, it's the lower threshold of criminal liability that will have the chilling effect. So the lower threshold is very important. It'll have the chilling effect in protest because people will be driven from the public square, potentially, by the fear of prosecution.
Well, they'll be driven from the immediate vicinity of abortion clinics, but if they actually want to influence public opinion, they've got no shortage of other places in the public forum where they can protest.
Yes, I agree with that, my lord. But again, that goes to the content of the Article 11 rights. It's a topic I'm going to turn to now, which is what does the Strasbourg court say is actually the content of the Article 11 right in this context, and the Article 10 right, and how is a balance to be struck. If I could move perhaps to that. Deal first briefly with the Article 8 issue. I've sketched the attorney's position in respect of that, and we've looked at the clause in question. The approach we adopt is informed by the Court of Appeal's analysis in the Dulgary and Ealing Council case, which you'll find at page 550 of the electronic bundle. Judgment's informative for a range of reasons, but it's a similar statutory scheme under the Anti-Social Behaviour, Crime and Policing Act 2014, which allows for the creation of public spaces protection orders. These are orders that have a similar effect to the access zones that apply in this case. But again, there are some differences. The Act itself requires specific consideration to be given to the Article 10 and 11 rights. That's in Section 72 of the Act. There's also a facility for a reasonable excuse defence in Section 67 of the Act. So this is an analogue, but on the key features, which we say go to convention compatibility, there are quite profound differences. So Section 72 requires 10 and 11 to be given consideration, and 67, importantly, includes the reasonable excuse offence. The order in this case was a 100-metre zone around a clinic. The High Court considered it to be justified in Article 11 terms, and held that the Article 8 rights of the service users outweighed the Article 10-11 rights of the protesters. The appellant in the Court of Appeal argued that the Article 8 rights of the service users weren't engaged at all, and that's dealt with at paragraph 50 and following. That's page 565. The Court of Appeal, paragraph 53, had no hesitation in rejecting that as a ground of appeal, recognising that there were autonomy issues in play for the service users. There were also expectations of privacy in play for the service users, and the court had no difficulty in finding that the Article 8 rights of the visitors to the centres were engaged. You'll find that at paragraph 60, page 568. What they didn't, the Court of Appeal didn't find was that the Article 8 rights of accompanying persons and service users were concerned. And again, following the rationale through, you can see that the autonomy interests are different, the expectations of privacy are different for staff and those providing services, and Article 8 was not found to be in play positively in those cases. And we adopt the same approach in respect of this case. Again, there's no dispute. The Attorney General of Northern Ireland recognises that there is an Article 8 consideration for service users. There's a need for protection for those using services, but it doesn't follow that it extends beyond that. The Article 11, the Article 8 rights have to be balanced against the other qualified rights, and the focus here is going to be on 11, 10 and 9 I don't propose to say very much about. We start with Article 11, and the approach has been in the Strasbourg authorities and also in the domestic authorities to consider the Article 11 jurisprudence to be the lex specialis in this context. That's what the Supreme Court said in Ziegler. I don't want to take you to it now, but it's paragraph 61 of that judgment. It's also what the Grand Chamber have said in one of the leading judgments called Lash, Mankin, and I'm going to take you to that in a little bit more detail. So the approach we'll take in this sketch is to look at the Article 11 rights and then 10 thereafter. The general principles can be found in three key cases. Those are the Grand Chamber decision in Kudravicius, which I'm going to take you to now, the Chamber decision in Lash, Mankin, and the Grand Chamber decision in Animal Defenders. So those are three key authorities which give us the substantive convention content here. Kudravicius, it's a 2016 decision, can be found at page 802 of volume 2.
Um, 802 seems to be in. It seems to be Animal Defenders.
Sorry, no, beg your pardon, my lord. It's 902. 902. So this is Kudravicius in the Grand Chamber. Decision of October 2015. Just note in passing that on the same date, the Grand Chamber gave judgment in a case called Pericek and Russia. Grand Chamber involving quite a number of the same judges, which is relied upon by Justice Pericek's an Article 10 case. But I just flag it because it's interesting that neither of the judgments speaks to each other, neither references the other, and they point in slightly different directions in a way that is of some import for the analysis in this case. But for present purposes, Kudravicius and Lithuania's Grand Chamber decision setting out key principles. The case related to protests or blockades by farmers in a context where there was a prior notification scheme. So the Article 11 protest right was limited by a scheme that required prior notification of the protest. And the protesters did give notice, but they exceeded the limits of the notification. They protested beyond the time limit and in a manner that caused significant disruption on arterial routes throughout Lithuania. That's the background to the case. The Grand Chamber addressed the applicability of Article 11 generally at paragraph 91. I take you to the substantive assessment in the case. That's page 923. So it refers here to the fundamental nature of the Article 11 right in a democratic society. It should not be interpreted restrictively. Covers both private meetings and meetings in public places, whether static in the form of procession, can be exercised by individual participants and by persons organising or gathering. And it applies to all gatherings at 92, except where the organisers have violent intentions or intentions to incite violence or reject the foundations of a democratic society. So the Article 11 right can be engaged in a great many circumstances and ought not to be interpreted restrictively. Paragraph 94, it's not lost, even if in the context of the protest or assembly, others engage in acts of violence or demonstration, provided that's not the intention of the individual. So the engagement of the right has a low threshold, and restrictions should be limited. The interference of the right is dealt with at paragraph 100. Again, this notes the way in which restrictions should be interpreted, at the top of page 925. Restrictions must be interpreted including both measures taken before or during a gathering and those such as punitive measures taken afterwards. It refers to the chilling effect that can be imposed on persons intending to participate in a rally, which amount to an interference. So again, the threshold for what will amount to an interference is set out there. The court also notes that in this case, while the conduct of the participants was reprehensible, there was nonetheless an interference. Paragraph 102 sets out the rubric for analysing an Article 11 case. Again, very familiar to us all. The interference constitutes a breach unless prescribed by law, pursues a legitimate aim, and is necessary in a democratic society. And most of the jurisprudence focuses on the latter question about it being necessary in a democratic society. In this case, in the reference, the attorney has not advanced the case on the basis that there's a legality problem. So despite concerns along the lines that I've articulated in analysing the bill, it's not contended that there is a legality problem on its face. However, when the court comes to consider the justice submissions and some of those by the Human Rights Commission, and the contention that really this can all be addressed by a Section 83 reading, or by a Section 3 reading, or by departments, public authorities disapplying the legal norms, then there is arguably a legal certainty issue. Because once we move into that kind of territory, and we're not arguing for that, of course, we're arguing against that, but if we move into that kind of territory, then it is difficult to forecast with the best legal advice there is what exactly the thresholds for criminal liability are. So there is a potential legality problem, not on our primary case, but in response to the case advanced by the interveners. But again, I can come back to that if I need to. The particular value of the Grand Chamber decision in Pedro Vickius is the statement of general principle on striking the proportionality balance. And this is found in the section of the judgment on page 934. Paragraph 142 and following. So it's again a foundation right of a democratic society, subject to a number of exceptions which must be narrowly interpreted, and the necessity for any restrictions must be convincingly established. Cross-reference my point about 5.2a really being met by B and C. When examining whether restrictions on the rights and freedoms guaranteed by the Convention can be considered necessary, the contracting states enjoy a certain but not unlimited margin of appreciation. And again, we'll be familiar with the usual rubric, which often says here a wide margin of appreciation. Certain but not unlimited is the approach, and the Strasbourg Court adopts here. Paragraph 145, top of page 935, again setting out general principles. Freedom of assembly as enshrined in Article 11 protects a demonstration that may annoy or cause offence to persons opposed to the ideas and claims it's seeking to promote. Any measures interfering with the freedom of assembly and expression, other than in case of incitement to violence or rejection of democratic principles, however shocking and unacceptable certain views or words may appear to the authorities, do a disservice to democracy and often even endanger it. A very strong statement of principle about the need to have a minimalist approach to interference with the Article 11 right. Paragraph 146. The nature and severity of the penalties imposed are also factors to be taken into account when assessing the proportionality of an interference in relation to the aim pursued. When the sanctions imposed on the demonstrators are criminal in nature, they require particular justification. And a peaceful demonstration should not, in principle, be rendered subject to the threat of a criminal sanction, and notably no deprivation of liberty. Again, we say that sounds on the 5.2a criminal liability thresholds here. This is a criminal case, ultimately. There's a requirement for particular justification. The penalty might be light by way of fine, but it's criminal sanction nonetheless. And as a matter of general principle, the Strasbourg Court set out its position in respect of that. The subsequent paragraphs deal with the prior authorization regime, which is not what we're dealing with here. The general principles pick up again at paragraph 155, page 937, where there's discussion of demonstrations and disruption to private life or ordinary life. So any demonstration may cause a certain level of disruption. This fact does not in itself justify an interference with the right to freedom of assembly. It's important for the authorities to show a certain degree of tolerance. And that I also observe the court will see at paragraph 158 through to 160, the concept of a positive obligation is introduced by the Grand Chamber. And so there's not just a negative obligation to not interfere with the Article 11 rights, but a positive obligation to secure the effective enjoyment of those rights. And again, that's something that could be addressed, for example, by a designated zone, as in the Dilgary case, or some other facility. None of that appears in the Northern Ireland Bill. There is no attempt to address the positive obligation features. And that's, again, a factor in this judgment and repeated in later cases. The court returned again to these concepts in the Lash Mankin decision, which is to be found at page 948 of the bundle. Say a little bit about the factual background to this. This is an interesting judgment involving Russia, and there are 15 conjoined appeals or applicants involved in this case, with diverse factual situations. Some of them are gay pride activists, some are political activists who are subject to restrictions under the Public Events Act in Russia. And of particular interest is one of the factual situations which involves, it's set out at paragraph 53. I'll just find the reference for that. This is page 960, the case of Yefremenikova and Russia. And these are described as gay human rights activists by the court. And they seek to engage in a series of pickets and protests outside court buildings in Russia. And I flag this because this part of this appeal deals with an analogy to a safe access zone, because there's a complete prohibition on protests outside court buildings. And the court deals with that in the substance of this judgment in a manner that's, we say, quite informative for a general convention analysis. So it's that aspect of the last Mankin decision that is of particular interest. In the course of considering that issue, which is a blanket prohibition in public spaces, the Strasbourg Court considered a number of international instruments. So, and this goes in part to Lord Reid's observation about the ability to protest elsewhere. And you'll find those at page 1000 and paragraph 313 is the first of them. It's the United Nations report on peaceful assembly and freedom of association. I see the clock's just turning to 1 o'clock, so I might, subject to the court, pick that as a juncture to pause.
Yes, if that's a convenient point, then we'll adjourn there and we can resume at 2 o'clock.
Thank you.
Welcome to the resumed hearing in the Supreme Court of the reference from Northern Ireland of a question as to the competence of a provision in the Abortion Services Safe Access Zones Northern Ireland Bill. We're hearing submissions on behalf of the Attorney General for Northern Ireland presented by Mr. McLennan, and I'll invite him now to continue his submissions.
Thank you, my lord. I'll take guidance from the court on timings. We did have a later start. I would have been scheduled to finish at 2:30, but I might need a little longer just to complete the submissions.
Yes, that's all right. Don't worry. If we need to catch up with time, we can make arrangements to do that.
Thank you very much, my lord. I was taking the court to the Strasbourg decision in Lash, Mankin in Russia. This is not a Grand Chamber decision, but it's quite an important decision, one which is heavily referenced by our Supreme Court in the Ziegler decision, a recent decision on a similar territory. And I was flagging for the court at page 1000 the reference to relevant international and comparative material. And I'll deal with this briefly. There are three references I want to flag here in respect of the issue about location of protest, and it goes back to a point that's been raised about the facility for protesters to go elsewhere outside an exclusion zone to make their point. So the international materials, I want to flag three aspects of it. Paragraph 313, page 1000, is a reference to the UN Special Rapporteur on the right to freedom of peaceful assembly. And I'll highlight for you paragraph 40 at page 1001, reference here to any restrictions imposed must be necessary and proportionate to the aim pursued. In addition, assemblies must be facilitated within sight and sound of its object and target audience, and organisers of peaceful assembly should not be coerced to follow the authorities' suggestions if these undermine the essence of their right to freedom of peaceful assembly. You'll see this concept of within sight and sound repeated through the international materials and picked up by the Strasbourg Court in its analysis. So that's the first reference. Second reference is a paragraph 315. Here it's quoting from the compilation of Venice Commission opinions on freedom of assembly. So it's a kind of a digest of analyses on freedom of assembly jurisprudence. And I'm highlighting for the court page 1003, paragraph 4.2, where it deals with restrictions on place. And again, this goes to the specific aspect of the Lash Mankin judgment dealing with blanket restrictions on protests at court buildings. So 4.2, the Venice Commissioner saying, location is one of the key aspects of freedom of assembly. The privilege of the organiser to decide which location fits best for the purpose of the assembly is part of the very essence of the freedom of assembly. Picking up with the next paragraph, blanket restrictions such as a ban on assemblies in specified locations are in principle problematic, since they're not in line with the principle of proportionality, which requires that the least intrusive means of achieving the objective should always be given preference. And then it recommends, two paragraphs down, that blanket bans on assemblies in the vicinity of government institutions and courts be deleted, and the management of security risks left to the relevant law enforcement authorities, and in reference to the positive obligation to facilitate and protect peaceful assembly. The third international reference is found at page 1012. This is the OECD 2012 guidelines, or OSCE, 2012 guidelines on freedom of peaceful assembly, and deals with a range of points, but in particular, you'll see at page 1013, again, the sight and sound concept. So as a general rule, assembly should be facilitated within sight and sound of their target audience. The paragraph 43, again, I won't read this, but there's a treatment here of proportionality and the blanket application of legal restrictions. Again, the court will find that of some assistance. Paragraph 101, again, this is all internal to the international materials. The sight and sound concept is restated, and the importance of being permitted to facilitate assembly within sight and sound is emphasised. And at 123, on the same, sorry, I think that's the last reference I have from that. So those three international instruments are actually then drawn upon by the Strasbourg Court at a later point in the judgment in the analysis of the proportionality balance. That's why I highlight them for the court. But it goes back again to the contention that Article 11 can be satisfied by allowing protest away from the locus at a point out of sight and out of sound of those to whom who are the potential target of the influencing, or in this case, or protest. The court rehearses the general principles set out by the Grand Chamber in Kudravicius. So that's from paragraph 412 onwards. So that's page 1046. You have a repetition here of the Kudravicius general principles. I don't intend to go through that again. What I say this judgment adds to the overall analysis of the jurisprudence is a material found from paragraph 430 onwards. That's page 1055. First point to note, I suppose, it's just at the paragraph 430. The Strasbourg Court actually found in that case that there was a legality failing. So it doesn't just fail on proportionality, it fails on legality, on the quality of law, because of the way in which the Public Events Act was being applied with lack of foreseeability. Court goes on, though, to engage in the proportionality analysis, in particular with respect to, you'll see at paragraph 431, case 19700. That's the one that I flagged for you. That's the case about the prohibition on court buildings. You'll see at 433, the Strasbourg Court refers to the international materials that I've just highlighted for you. And in particular, the footnote at 161, 162 takes you back to those passages that I've just identified. And you'll see, again, the court is referring to the fact that those bodies all recommend that blanket bans be avoided. They tend to be over-inclusive and disproportionate because no consideration can be given to the specific circumstances of each case. Sorry, I see my Lord Jones raises his hand. Lord Lloyd Jones.
Mr. McGleenan, I'm sorry to interrupt. I don't know if I'm the only one affected, but I'm losing the signal. I'm not able to hear you. You're coming through intermittently.
I don't know if that's a problem of general application.
No, I've not.
And I've lost sight. I've lost sight of all the other members of the court.
Sounds like a problem at your end. I can't hear Lord Reid.
I beg your pardon. I muted myself. I think the problem specifically affecting you, Lloyd Jones, and our engineer will have to contact you to try to sort the problem. So we'll wait a few minutes to see.
Thank you. Sorry about this.
Can I check, Lord Lloyd Jones? Have you been contacted by an engineer? It seems not. I wonder if our usher, Derek. Oh, here we are. Yes. Well, our engineer has been asked to look into Lord Lloyd Jones's computer settings. Lord Lloyd Jones's system is being checked at the moment, so we'll just be patient.
Right. I don't know if you can hear me now.
Yes, we can.
Good. My problem was hearing Mr. McGleenan.
Yes. He had taken...
I don't have an image on the screen of Mr. McGleenan.
Well, the rest of us do.
Right. Mr. McGleenan, I can now see you. Could you say something, please?
Yes, Lord, it should pick me up if you hear.
I'm certainly picking you up now. That's good. Thank you so much.
I think we're ready to resume. Thank you.
Thank you. It's for my Lord,
Well,
Lord Jones.
Explain what Lord Jones may have missed. You had been taking us through the judgment in the Russian case, and you'd taken us to paragraphs, particularly 430 and 433.
Yes.
We'd reached 430, and I can mark that. I can read 433.
Yeah.
Thank you.
Was particularly the second sentence's reference to the international materials that we looked at earlier.
Yes. And the purpose of looking at these paragraphs was these are additional to the jurisprudence in the earlier Grand Chamber case, and this is a particular focus on the site-specific prohibitions. And I was about to take you to 434, and again, the statement of principle here about a general ban on demonstrations in the second sentence can only be justified where there's a real danger of their resulting in disorder which cannot be prevented by taking other less stringent measures. And the court refers to the need for the authority to take into account the effect of a ban on demonstrations which do not by themselves constitute a danger to public order, but only if the disadvantage of such demonstration being caught by the ban is clearly outweighed by the security considerations justifying the issue of the ban, and if there's no possibility of avoiding such undesirable side effects by a narrow subscription with scope in terms of territorial application and duration, can the ban be regarded as necessary within the meaning of Article 11.2 of the Convention? And that's a useful passage to measure the Section 5.2, Clause 5.2a provision against. You'll see then at 4.
When they say that, that's in the context of a case where there's no question of being competing convention rights to be protected.
Yes, I anticipate that point. I think that's a point raised by some of the interveners. The answer to that in this context is there will be cases here where there's a competing Article 8 right, the service users case, Clause 3.3a. There will, on our case, also be 3b and 3c cases of accompanying persons and general workers and those who are providing services caught by the same provisions where no Article 8 rights engaged. So that's the difference, I think, in this context. Lord Lloyd Jones has raised his hand again, sorry.
I'm sorry, you're breaking up intermittently again, Mr. McGleenan. I'm very sorry about this.
Okay. I'm not sure what the problem is. We're actually in Supreme Court, so our signal is coming from the court. The technicians will be able to tell if we're the source of the difficulty, I hope.
I don't think you can be, because I'm not in the court and I can hear you perfectly well.
Yeah.
I think the problem must be at Lord Jones's end, which is reception.
I mean, Lord Reid is breaking up as well.
Yeah.
Lord Reid is breaking up as well.
It looks as though the Workley engineer hasn't sorted the problem. Could our broadcast engineers get back in contact with him to help Lord Jones further? And I suggest the rest of us simply switch off our sight and sound and effectively have a short adjournment, but ready to resume as soon as the problem is sorted. And Lord Jones, if you can Well, I'm afraid we're being plagued with technical problems today, but we're, I think, ready now to resume. Mr. McLean.
Thank you, my lord. I'm presenting on the Lash Mankin case and trying to make a bit of headway on that point. I think I was answering a question from you about the competing rights, and I think the line we take is one of the peculiarities of this particular statutory provision is that it actually captures circumstances involving those who do not actually have Article 8 rights in play, and that's sounds on the overall proportionality point. So for those reasons, we say the Lash Mankin doctrine as set out here is still applicable to this case.
Why do you say that? I mean, for example, if a woman who's wanting treatment goes with her friend, both women are going to be the targets of the sort of behaviour that we read about in the parliamentary proceedings. Why shouldn't?
I hope it's not a problem at my end, but I didn't. You meant to mute partway through that observation, I think.
Yeah, I had.
I'm so sorry. I was asking really why, if say a woman goes with her friend to a clinic of this kind, and the two women run the gauntlet of the sort of behaviour that we read about in the parliamentary proceedings. Why do you say it's only the pregnant woman's Article 8 rights that are engaged?
I think there's a sliding scale here between the service user, the pregnant woman, or the person seeking counselling, the accompanying persons, who can be a range of people, and the staff and service providers. So there are probably 4 steps in the chain. What we can say with, and we don't dispute, is Article 8 rights are certainly engaged with the service user. There will be accompanying persons whose Article 8 rights are not in play because they're not seeking the service in order to vindicate any personal autonomy. They're not.
But if they're being, for example, spat at, or having abuse shouted at them, why are their convention rights not engaged?
That's the other provision, my lord. The answer to that is that's a 5.2b and c case. We're not complaining about 5.2b and c. We're talking about the indirect influencing case. So it's a different order of interference. So we're focusing on the lower end of the threshold, and we're saying in that context, the Article 8 rights of the accompanying person are not engaged by being the subject of indirect influence. So if we focus sharply on the offence, I'm not taking issue at all, nor is the Attorney General for Northern Ireland, with the types of behaviours my lord's describing. Those are objectionable, and those are captured by the statutory provision. What we're taking issue with is an entirely different scenario, which is someone behaving passively, perhaps standing, holding a poster, saying something like "think again" or "choose differently." Something as straightforward as that could be an indirect or recklessly indirectly influencing. That's the kind of behaviour that we're concerned about here. So it's categorically different from the BC case, which involved the service users and the being subject to harassment, alarm, or distress. So if we actually disaggregate the statute and focus on the objectionable provision, I think the analysis bears up. And it also bears up, as I say, in the gradations. Look at the difference between the woman seeking the treatment, the accompanying person, the staff member who works in the clinic, and the person delivering water or food to that facility. The rights that might be engaged, there may be rights engaged there. There may be A1P1 rights engaged, but they're not Article 8 rights in the context of influencing. So if we actually tease apart the issues that are in play in Section 5.2a, I think the analysis still holds good. And I stress the Attorney General for Northern Ireland is not bringing this reference in order to facilitate the types of objectionable behaviour that my lord has described, because the statute catches that, and that's by no means the problem in this case. But back if I may to Lash Mankin.
Can I just ask a question, please?
Yes.
So if we just confine ourselves to the service users, as you've described them, would you accept that in relation to those people, there is no application of the sight and sound objection that you're putting forward? Because you need to protect their rights, that's not in dispute. And therefore this line of authority becomes irrelevant to them. Do you accept that?
I think I'm wary of accepting a proposition as broad as that, because I think where it gets you to is you still need to strike a balance with the service user, but the weight that's attributed to the service user's rights is going to be much more compelling than in the other cases. So we don't set aside the balance in those circumstances and say it's a trump card, an absolute trump card, that Article 8 is engaged in those circumstances. But clearly the weight attributed to that will be very different in those cases. So
yeah, but so you're saying the sight and sound argument, that is the right to protest in a particular location, must give way in certain circumstances?
In certain circumstances, yes, there will be scenarios. But again...
So we're then arguing really about whether these circumstances are within that or not. Otherwise, it would seem to me that to follow your argument through fully, you'd end up with no safe zones for anybody at all, which can't be right.
Certainly that's not what we're arguing for. That's not the case that we're advancing. The sight and sound requirement will be modulated or tempered by the behaviour that's being addressed. So, as I say, going back to 5.2a, the behaviours that are being addressed here are not those that cause alarm, distress or harassment. They are much more passive in nature and can be engaged at a very low level.
Can I
just ask a follow-up question to Lord Reid's question? When you say the rights, there's no Article 8 rights engaged in relation to the people working at the abortion services or those accompanying, at least in certain circumstances, those accompanying, why isn't the argument that in order to properly protect the Article 8 rights of the service users, you need to also protect people who work at the abortion services and or wish to accompany, or where the service users wishes these people to be accompanying them? Why doesn't it flow on from the Article 8 rights of the service users that those other people must be protected as well?
Well, we'll put the point a different way. In one sense, the service users can only avail of the service if there are workers prepared to go there and conduct the exercise. It's a much less objectionable protest to direct influencing towards people who are at work than it is to vulnerable people who are going to seek a service. And if the right to protest isn't eroded of all meaning, then it must suggest permit some means of expressing a view to those who work there. And interestingly, the Court of Appeal in Dulgari were of the view that the Article 8 rights could be balanced in circumstances where protest was still facilitated. Because what was key in that case, and the key differentiating factor for this case, is that there was a designated zone for protest. So protesters were able to make their point within sight and sound, but at a distance, and the balance was struck by that method. What's problematic with the statute provision we're looking at here is there's no facility at all for protest, even in a designated area proximate to the site. So the Court of Appeals already looked at this point, and as I say, we in essence stand behind that analysis, because the court said we can readily see Article 8's in play with the service users, but not at all clear in respect of the others. But still was of the view that Article 8 could be protected with a protest allowed in certain limited ways. So that appeared to us to be a means of striking the right balance. That is not available in this context, in the Northern Ireland context.
Can I ask a question about the other side of the equation? The sight and sound aspect of Lash Mankin seems to be primarily directed at protests towards lawmakers. But do you say that Articles 10 and 11 protect a right to persuade someone who has absolutely no power over what abortion law should be, but who is a private person availing themselves of that service? It doesn't seem to be similar to the kind of protest against government bodies, people who influence what the law is. But how far do Articles 10 and 11 go towards protecting my right to persuade somebody, another person, not to take advantage of a law which they have no power to change? Is it not more to do with about changing laws or changing political manifestations?
I mean, I think the position in terms of the debate about the legality of abortion in Northern Ireland is settled. I mean, we've had primary legislation that's no longer in dispute. The service will be available, subject to certain political dimensions. That's not in dispute. The parallel that's being drawn with and these aren't perfect parallels, obviously. The Russian scenario is not protesting at lawmakers, but it is seeking to hold gay rights, pride type events in the precincts of courts, not the lawmakers, but courts who make decisions. And again, it doesn't seem to be a protest directed at influencing legislation, but simply influencing the state infrastructure. Now, that may be misguided or misdirected or whatever, but what Article 11 seems to protect is the right to engage in non-violent protest in a manner that's in sight and sound of an audience that would in some way be influenced by the action. And again, we're not, on behalf of the attorney, we're not supporting a particular point of view in respect of this, or
influence to do what? What are they? It's not influencing to do anything in the political sphere.
No, I think they were attempting to influence them not to avail of the service, to make a different choice.
And that, you say, is protected by Article 10 and Article 11 rights?
Well, it's not clear why that's objectionable per se. It's not a reprehensible act, which is the kind of concept the Strasbourg Court is engaging with. It's not violent. People might disagree with it, but there'll be many who don't. So we're in that kind of territory, and it's not necessarily an attempt to change the law, because the law is what it is. It's a protest limited in its nature, and I think our submission here is it's within the envelope, a similar envelope to that which the Strasbourg Court has found worthy of protection in a range of cases. And the Strasbourg Court has found much more reprehensible conduct to be within the envelope of protection. I mean, the case of Faber, for example, we cited, is a case involving the flying of objectionable flags in respect of fascism at a Holocaust memorial site. I mean, there are the types of conduct that the court has said, no matter how objectionable we see and find it to be, it still falls within the area of protection. My Lady Chief Justice, I think mute. Still mute.
Yes, thanks. The decision you were looking at, paragraph 434, deals firstly with measures to militate against public disorder. Okay?
Yes.
Then I think where you are is looking at the second paragraph, demonstrations which do not by themselves constitute a danger to public order. Is that where you are?
Yes, exactly.
And if you read in that case, security considerations I think you can read in there Article 8, protection of, certainly on your case, service users, arguably others. I know, but you're clear about service users.
Yes.
Yeah. So
Yes.
you can have a ban. It says only if the disadvantage of such demonstrations being caught by the ban is clearly outweighed by the security considerations. Read in Article 8 considerations, which are explained in the Health Committee's report, I think, the effects on the service users, which justify the issue of the ban. I'm not sure there's much controversial about that so far. No.
No.
Then, are you really at the next part of this paragraph about necessity because of what's described here as undesirable side effects of the ban by a narrow circumscription of its scope in terms of territorial application and duration? Is that what your argument comes down to?
I'm not confining it to that, but that's certainly important because, again, looking at the offence provision, 5A is the objectionable section. B and C still captures what most people would consider to be the objectionable behaviours. Lady Rose has identified those. They would be caught by that part of the statute. We're not raising any issue about that. So, looking at a narrow circumscription of scope, the narrow circumscription of scope is achieved by simply using the 5B and C provision. There is no territorial there's no the territorial scope. You've heard my points about that is potentially very extensive, and there's no temporal limitation. And one of the features of this decision, if you just turn over paragraph 437, one of the reasons why the Strasbourg court found that the proportionality balance was not correctly struck in this case, the Russian case, was that the restriction was not limited in time. Yeah. Applied to the entire territory. So it's the temporal scope, the geographical scope, and the fact that there is a perfectly effective tailored provision in 5.2b and c, which does the job, which I think is those are the key features of the case as far as we're concerned. And the Strasbourg court that found that in light of those sorts of problems, it hadn't been shown that the ban was proportionate in the circumstances. And in 440, you'll see again the court saying the ban should be tailored narrowly to achieve the particular interest. And we say it's not narrow actually, but there is a tailored provision in B and a tailored provision in C which meets that need. And that's what we take out of the Lash Mankin. And again, I'll just finish on the point 441 of the same section. The Strasbourg court saying it's the absolute nature of the ban, wide discretion in the vicinity, and so forth that makes a difference. So it's a collection of those components together that causes the problem in this case.
But just on that, the necessity of the ban described there relates to the nature of the security considerations. So there has to be a relationship. And here, as we've heard, there are very stark effects raised in relation to the Article 8 considerations of the service users, are there not?
Yes, but we say there are problems elsewhere in respect of that.
Yeah, thank you.
I don't know, but perhaps we need to bear in mind in relation to 2A, the anxiety of the Assembly, which comes over in the debates to avoid leaving loopholes because of the difficulties that had arisen in the enforcement of existing laws, the police not being either able or willing to enforce existing laws in relation to harassment and the like. And although such laws existed, and they effectively duplicate, it certainly duplicates C, and B for that matter, I dare say there would be a criminal offence that might well cover that. Do we not need to bear in mind that if the context is one where there is a real problem of the practicality of enforcement, unless you draw the offence widely, then that in itself is a reason supporting the justifiability of a widely drawn offence.
Yes, I mean there's a different answer to that, which is you can draw the offence widely, but you can temper that with a reasonable excuse defence. And what we have here is a very widely drawn offence.
Yes, but of course, the Parliament didn't want to have a reasonable excuse defence, and it eliminated discretion and so forth generally from the legislation, so as to make it, so as to get as close as they could to a clear law criminalising the sort of thing that was going on.
Yes, that's not contentious. I think the issue there is what space is left for Article 11 rights, what space is left for Article 10 rights, and I think the analysis we've put forward is there is no space left for it that meets the general requirement to have some efficacy in the right.
Yeah, well, I mean, the other view, of course, would be that they only have to go 100 meters or 100 yards, whatever it is, from the facility, from
the land on which the premises sit. Yeah. Again, we've got points to make, and we've made already. I won't labour them about the elasticity of that point, and that goes to geographical temporal application. So, I've probably said as much as I need to say about the Lash Mankin decision. I said there was a further Grand Chamber decision of some importance in this context, and it is the Animal Defenders decision, which is at page 751 of the bundle. Animal Defenders is referenced in the Lash Mankin decision, and one of the reasons it's referenced is because the Strasbourg Court is inviting a comparative analysis of the quality of the parliamentary and judicial scrutiny of a general measure that didn't have the type of facility we're talking about. So Animal Defenders is an authority that keeps cropping up in this context and looms large, I think, also in the justice intervention in this case. But the principle that's being stated in Animal Defenders is in respect of a ban on political advertising, which was a general prohibition introduced without exception in the United Kingdom by the Communications Act 2003, although it actually replicated legislation that was in place from 1954. Light of time constraints, I'm not going to take the court through this line by line, but from page 763, from paragraph 35 of the judgment, there's a very detailed treatment of the background to the Act, the 2003 Act. And what you see here is, again, antecedents in earlier legislation, the 1954 Act. You see the Neil Committee on Standards in Public Life reporting on public advertising. You see a white paper being produced. You see extensive consultation on that white paper and a draft bill in paragraphs 41, 42. You see the involvement of the Joint Committee on Human Rights, paragraph 43, which raised issues and concerns. You'll see the bill being introduced into Parliament, paragraph 48. The department sponsoring the bill produced a memorandum engaging with the Joint Committee on Human Rights analysis on convention compatibility. That's referenced at paragraph 50 and 51. Then, unusually, paragraph 52, and the Strasbourg Court lays emphasis on all of this, the department produced an explanatory note which exposed, it looks like, Attorney General's advice or senior counsel's advice on the convention compatibility issues in the legislation. And all of that was put before Parliament in the law-making process. Now, there's a point I think I can make by reference to submissions made earlier today. That's a world away from the parliamentary scrutiny and consideration that applied to the Privates Members Bill that became the Act that we are considering now. The quality of the legislative scrutiny is of a different order of magnitude. Similarly, in the Animal Defenders case, the Strasbourg Court was impressed by the fact that our appellate court, including the House of Lords, had also opined on the Strasbourg principles that were applicable there. So there was a judicial element of scrutiny that went into the lawmaking process. And all of that informed the court's decision on the proportionality of the measure. But the passages that are most frequently cited in Animal Defenders are found at page 787. And that is at paragraph 106. So, and the statement of principle there is that it's recalled the state can, consistently with the convention, adopt general measures which apply to predefined situations, regardless of the individual facts of each case, even if this might result in hard cases. So something like 5.2a can be put forward if certain conditions are met, even though it gives rise to individual hard cases. But there's a recognition that there's a potential proportionality problem arising. You'll note also paragraph 107, a reference to the court having examined the necessity for those sorts of general measures in a range of contexts. And you'll just, in passing, and this goes to a justice point, that Animal Defenders says nothing to the criminal paradigm. You'll note it at the penultimate line of paragraph 107, the reference to assisted suicide, and the footnotes of paragraph footnote 50 takes you to Pretty in the United Kingdom. Pretty in the United Kingdom is a general measure in the criminal justice paradigm in the United Kingdom, because that's assisted suicide, which again had a general prohibition measure without any scope for mitigation in a hard case. So Animal Defenders, Strasbourg Court, the Grand Chamber, was actually looking at case law of its own court that dealt with criminal jurisdiction issues in the United Kingdom. Paragraph 108, what they say is what emerges from that case law, including Pretty United Kingdom. In order to determine the proportionality of a general measure, the court must primarily assess the legislative choices underlying it, the quality of the parliamentary and judicial review, the necessity of the measures of particular importance, in this respect, including the operation of the relevant margin of appreciation. The proportionality discussion then is at 113, following, that's page 789. Paragraph 114 looks, again, in shorter form at the phases of scrutiny. And in the final sentence on that paragraph says the prohibition was therefore the culmination of an exceptional examination by parliamentary bodies of the cultural, political and legal aspects of the prohibition as part of the broader regulatory system governing broadcast public interest. Paragraph 116, the court attaches considerable weight to these exacting and pertinent reviews by parliamentary and judicial bodies and notes then that the prohibition was specifically circumscribed to address the precise risk of distortion the state sought to avoid with the minimum impairment of the right of expression. So one of the things the court can do is test clause 5.2a against the barometer of Animal Defenders. Look to the quality of parliamentary and judicial scrutiny. We say bears no comparison. It's not pertinent and exacting in the same way at all, but nor is it tailored or circumscribed to address the precise risk of distortion, in that case, the state sought to avoid with a minimum impairment. It has none of that. It is, if you're looking for the tailored provision, it's not in 5.2a, it's in 5.2b or c. And those provisions are, we say, aligned to the Animal Defenders line of reasoning. So, again, this is not an Article 11 case, it's an Article 10 case. But it is a helpful tool, we say, to measure the difficulty that arises in the effect of the clause in question. Now, the Human Rights Commission rely on the Animal Defenders decision, and they say, actually, the Northern Ireland Assembly struck the right balance, struck the proportionality balance in the provision. That's their case. Justice disagree. They say, no, that's not what happened. But if there is a problem with the proportionality balance, it's mopped up later on by using Section 83, 2 of the Northern Ireland Act, Section 3 of the Human Rights Act, and Section 6. So we have two august bodies dealing with human rights jurisprudence, taking different views about the application of the Animal Defenders test to this case. In itself, we say that illuminates the difficulty that arises from a provision of this nature. But what we say is that Animal Defenders can be used in this context, even though itself it was not a criminal case, because it's informed by the judgment in Pretty. I should say, and I should flag the decision in the case of Parent-Check, which is another Grand Chamber case given on the same date as Kudravicius. I alluded to this earlier on. it's found at supplementary bundle 1137. So this is volume 7. Have it here. Sorry. And I flag parent check because it's relied upon by Justice as part of their critique of the decision of the Divisional Court in Kukurian, which I'm going to come to in a moment. So, parent check, supplementary 1137. Yeah. This is an Article 10 case, and as I've indicated, decided the same day as Kudriva case, or dated the same date. The issue here is about genocide denial. The individual in this case was involving himself in protests and pickets denying the Armenian genocide, which was something that was prohibited under Swiss law. It's just for a note, you don't need to go to it, but I think it's paragraph 35 of the judgment sets out the Swiss law that Article 261 of the Swiss Criminal Code has a specific prohibition. It's paragraph 32 of the judgment, page 1166. It's criminalized as someone who seeks to justify or trivialize genocide. That was the issue in the case. But the legal point that's emerging from this arises at paragraph 274 and 275. And here you'll see the Grand Chamber is dealing with the balancing of rights between freedom of expression and Article 8. And it's referring to this provision of the Criminal Code, which criminalizes genocide denial. Paragraph 275 is the pertinent provision. So refers to what the Swiss government were doing and refers to the fact that there were two concepts to be balanced here. It said that halfway down that paragraph, the concerns demonstrated that in applying the provision in individual cases, the Swiss courts needed to carefully to weigh the countervailing interests. Indeed, an interference with the right to freedom of expression that takes the form of a criminal eviction inevitably requires detailed judicial assessment of the specific conduct sought to be punished. In this type of case, it's normally not sufficient the interference was imposed because its subject matter fell within a particular category or was caught by a legal rule formulated in general terms. What is rather required is that it was necessary in the specific circumstances. Now, this point is relied upon by the justice interveners to undercut the decision of the Divisional Court in Kukurian to the effect that it is not for the court to conduct a proportionality assessment where it has an offence before it which doesn't have a reasonable excuse provision. The interveners point to this ruling of the Strasbourg Court to say this is suggesting it should be done by the court. Now, the important points are in the last two sentences, and you'll see an interference with the right to freedom of expression that takes the form of a criminal eviction inevitably requires detailed judicial assessment of the specific conduct sought to be punished. The word judicial appears there, so it suggests this is to be done by a court, and it's not normally sufficient that it falls within a particular category caught by a legal rule formulated in general terms, i.e. animal defenders. What's required of this is necessary in the specific circumstances. This is pointing towards this being the responsibility of a court. There is a later decision of the Strasbourg Court in a Bulgarian case called Hanjivsky, which is found at page 1012 of the supplemental bundle. And this is also flagged by the justice interveners. And what you'll see here, it's a slightly different case, rather more trivial circumstances, mocking a politician by painting him as Father Christmas. Challenge to the conviction results in a reference to Strasbourg. But the same issue arises about how one strikes a balance and who strikes the balance in an Article 10 case, and it's dealt with here at paragraph 52, page 1025. So this is in 2021, a number of years later, the Strasbourg Court dealing with the same sort of point. And the last two sentences of paragraph 52 bear consideration. When an interference with the right to freedom of expression takes the form of a penalty, it inevitably calls for a detailed assessment of the specific conduct sought to be punished. Now, you'll note that's slightly different language than the Grand Chamber used. The Grand Chamber talked of a conviction and it inevitably calling for judicial assessment. Here it's talking about a penalty, and assessment doesn't say by the court. It goes on to say it cannot normally be justified solely because the expression at issue was caught by a legal rule formulated in general terms. Now, we see that or read that as a retreat from what was said in the Perenchek case. Perenchek itself does not align with Kudrivicius, a case decided on the same date involving similarly constituted court. What seems to be being said here is that where there's a penalty, there needs to be assessment of the conduct sought to be punished. We read that as a reference not to the court, but as a reference to the legislature. So in formulating the law, consideration ought to be given to the conduct that ought to be punished, and it cannot normally be justified solely because the expression was caught by a legal rule formulated in general terms. Now, these two authorities are relied upon by justice, as I say, to engage in the challenge to the Cookerian analysis, to which I'm just about to turn. So I'm flagging these points. The point will become clearer as we look at the domestic authorities, which is the final topic to which I want to turn. The issue that's raised here is really not an issue on the Attorney General's reference. It's an issue that emerges out of the interventions in response to the reference. The decision in Cookerian, we understand, was a subject of an application for permission to appeal to the Supreme Court. We don't know why, but that appeal hasn't proceeded. But clearly, the tenor of some of the submissions advanced by the interveners is directed to that decision rather than the Attorney General's reference. But it is important that we analyse, and the court analyses this issue. And can I invite the court to look at what I'm about to address in terms of two competing lines of authority? There's a line of authority from the English Divisional Court, which begins with a case of DPP and James, leads to a case of Bauer, another case of Abdul, and results finally in the decision in Cookerian in 2021, which is on point for this litigation. There's another line.
Mr. McKinnon, can I just ask how long you're going to deal with this? I mean, we're certainly very interested in this, but the reason I'm asking is it's now 3:10, and you lost half an hour this morning, and you lost about 20 minutes with Lord Lloyd Jones this afternoon. But there is a limit to how long we can allow you. How long do you think you're going to take on this?
Could my Lord allow me 10 minutes?
Oh yes. Well, that's no difficulty at all. Very well.
Yes. I'll be brisk with it. The decision of James and DPP is found at supplementary bundle, page 362. It's authorities 5. This is a challenge to a Public Order Act conviction, and there are a series of cases involving convictions under the Public Order Act. The Public Order Act has two types of offences: offences which include a reasonable excuse defence and offences which don't. And the issue that arises, and it's relevant to Ziegler and the general treatment of these issues, is whether or not there is a task for the court to perform in a proportionality analysis in both types of cases, i.e. those that have a reasonable excuse defence and those that don't. Ziegler in the Supreme Court was a case dealing with a reasonable excuse defence offence, and the Supreme Court in Ziegler said it's for the court to conduct a proportionality analysis in assessing that offence. what is being developed in argument in the reference here by the interveners is the contention that Ziegler type analysis extends to the other category of case. In other words, the no reasonable excuse defence case. And that's the 5.2a. That's what we're dealing with. So the argument is the Ziegler analysis that the court must conduct a proportionality exercise itself in trying the criminal offence applies to this type of case. And why that matters is because it is being said that you don't address these points through a reference, as we are doing. What you do is you allow the courts to deal with it after the fact. That's the point. In a nutshell, what we're saying is that Ziegler very deliberately confined that line of argument to the types of offence that carry a reasonable excuse defence. It did not extend that line of argument, that analysis, to the no reasonable excuse cases, like our case. And we rely on the decision of the Divisional Court in Kukurian, recent decision in 2021, which supports that proposition and says Ziegler doesn't speak to this type of case. The reason why I take the court to James and DPP, that's page 357 of the bundle, is because that is the authority which traces this distinction. And you'll see the court deals with from paragraph 15 onwards with the line of cases that are relevant to this analysis. And those cases are a case of De Haal and later a case of Bauer. And what the Court of Appeal found, the Divisional Court found, was that the De Haal case, which said a court is required to conduct a proportionality analysis of whether a prosecution is necessary, was wrongly decided. So De Haal was wrong. And they say Lord Justice Moses accepted that De Haal was wrong himself in a case called Bauer. And that's quoted at paragraph 19 of the judgment. And you'll see that in the indented quotation by letter D. There was then a separate decision in a case called Abdul, which also suggested that the court should conduct a proportionality analysis in a case where there was no reasonable excuse defence. That too was the subject of a decision by Lord Justice Davis. Later in this same judgment, at paragraph 369 or page 369, he too disavows the analysis, and you'll see that in paragraph 52 and 53 and 54, where he notes that Lord Justice Moses recanted from taking this approach. And in paragraph 55, he says, it follows that I myself recant from what was in effect an unduly deferential and insufficiently critical endorsement in his own case of Abdul. Stepping back into the judgment in James and DPP, you will see paragraph 32, the issue that's in play in the background in this case is engaged. So it was argued there, you'll see at paragraph 32, that there was a need to consider the interaction between the offence alleged and the rights of the accused under Articles 10 and 11. How do those rights become part of the consideration of the trial? The court saying the fact that proportionality of the decision to prosecute cannot be raised, otherwise an abuse process, does not mean that Article 10 and 11 cannot play their proper role. And then it distinguishes between two types of offences, importantly, paragraph 34 and 35. For some POA offences, the position has been clear for some time, refers to Norwood and Hammond. These rights and the qualifications and the proportionality form part of the statutory defence. So if you have a reasonable excuse defence, a court will engage in a proportionality analysis in dealing with that criminal prosecution. There are other criminal justice and public order offences in paragraph 35, of which Bauer is an example, whereas the court held, once the specific ingredients of the offence have been proved, the conduct of the accused gone beyond what could be regarded as reasonable conduct in the exercise of convention rights, the necessary balance of proportionality is struck by the terms of the offence creating provision without more ado. We are in the second category. We're in the paragraph 35 category, where there isn't a role for the court to engage in a proportionality analysis. It's meant to be in the statutory provision. If it's not in the statutory provision, that's a defect and it's not competent. That's our case. But that's where it's meant to be if it's not in the reasonable excuse. Now, that then was addressed and considered by the Lord Chief Justice and a panel in the Krikurian case. That's in tab 3. Sorry, this is the first bundle of authorities, page 442. So, Lord Burnett's giving the judgment of the court, page 443. The central issue is whether the decision of the Supreme Court in Ziegler requires a criminal court to determine in all cases arising out of non-violent process whether the conviction is proportionate for the purpose of Article 10 and 11. And just to say this is wrongly decided. So that's where this is coming from. We say this is correct, doctrinally correct. Again, in the interest of time, I won't labour the point, but it's a judgment that picks up this issue at paragraph, if we pick it up at 49, page 453. The proposition the respondent has urged this court to accept is an attempt to establish new principles of convention law which go beyond the clear and constant jurisprudence of the Strasbourg Court, refers to Ulla and to my Lord Reid's judgment in AB 2021, paragraph 57, which you'll be familiar with. And it's argued that in paragraph 51 and 52, that it's necessary for the prosecution to prove in these types of cases that a conviction be proportionate after carrying out a fact-sensitive analysis, or in the alternative, that you read down the statute provision or read into the statute provision a requirement for proportionality assessment. And what follows then is the Lord Chief Justice going back to James and DPP, going back to Bauer and indicating that the approach was corrected there. And ultimately, if you move to paragraph 67 of the judgment, you will see for these reasons, the court saying it's impossible to read the judgment in Ziegler as deciding there's a general principle in our criminal law that a person is being tried for an offence which does engage Article 10, the prosecution, in addition to satisfying the ingredients of the offence, must also prove a conviction be a proportionate interference with those rights. So Ziegler deals with a case with a reasonable excuse. The contention is the same approach should be read across, and the divisional court said that's wrong. And it said it was wrong in reliance on earlier weighty divisional court authority in Bauer and earlier authority in James and DPP. And what's being suggested by the interveners is this is wrongly decided, and what we really should do is expand Ziegler into this category. And doctrinally, the divisional court has rejected that. And you'll see the reasoning for it is set out at paragraph 69 and 70.
Mr. McGleenan, can I just ask a question? What is your submission in relation to the Northern Irish case of Lee Brown?
Yeah. I appeared in that case for the prosecution, and Lady Chief Justice will recall it. That's a case where these lines of authority, which I'm opening to the court now, were not subject of any consideration or debate. We didn't examine this at all. What happened in Lee Brown was it was taken as a given, essentially, that the Ziegler analysis applied to the public order offence in question. So we didn't actually have an argument on this point. So it's not a case that actually grappled with the competing lines of authority. In fact, didn't grapple with any of the lines of authority that are sounding on this issue. So,
but on your approach today, you would have to say it was wrongly decided, would you not?
I think that's right. Yes. And I bear part of the responsibility. I didn't draw the authorities to the attention of the court, although Krikurian only emerged after the Lee Brown decision. That's a decision of March 2022, so we didn't have it. And all of this was perhaps below the line of vision of counsel, and we didn't serve the court well in that regard. But on this analysis, we say...
Because I'm right in saying that there was no reasonable excuse defence on the in relation to the events in issue in that particular case, and yet a Ziegler fact-specific analysis was undertaken.
Yeah, that at the point, I put it this way, the point was assumed rather than argued for either way, and the court proceeded on that basis. So I think that's where we get to on that. But what we say, what's the countervailing line of authority? The countervailing line of authority...
Yeah, can I just ask, with Ziegler, it seems that the way you've presented it so far and the way that Justice presented it is that it all turns whether there is a reasonable excuse defence or not, which seems odd when some of the statutes predate the Human Rights Act. But is the presence or absence of a reasonable excuse defence an example of a broader consideration, which is, does the statute as drafted in fact strike a proportionality balance itself, or is it to be interpreted as leaving to the magistrates or the jury to strike that balance? And one could have a sort of part-way house where one could say, all right, when striking a proportionality balance, the magistrates' court, it's not up to them to decide whether 100 metres was right or whether it was right to have these safe access zones, whether it was right to include 5.2a. What they might need to look at is look at this specific conduct, which may not have been in the contemplation of the legislature. It's still open to them to say that it would be a breach of rights. Generally, looking at this legislation, it is intended that the legislation itself strikes the balance, and that's something separate from whether it actually includes a reasonable excuse defence or not.
I think there are two ways through this. In one sense, you either have a reasonable excuse defence, maybe there are more than two, but for the sake of discussion, two. Reasonable excuse defence, or you bake the proportionality balance into the provision. So does it reduce to this, a question of whether or not the proportionality balance is properly baked into 5.2a? We say it's not. If it's not, then it's a competence problem, and the court can identify it's readily corrected by resorting to the first method, either modify it by reasonable excuse or strike the balance slightly differently through the wording or the other features of the Act. Now, interestingly, interveners say, don't worry about all of that now, don't be doing this now, let the bill stand and it'll be mopped up through the criminal process. Well, that's trouble, we say, because that's subject to the vagaries of litigation. We don't know if that's going to happen, and you're relying on summary prosecutions in the Magistrates' Court to develop jurisprudence in an issue in which expert bodies are currently disagreeing before this court. That's not easy, we say. There's a more straightforward route, that is to address the issue through competence. There's a separate problem. In order to get into that Section 3, Section 6 reading to cure the issue, or Section 83 of the Act, you have to be getting into the territory of saying, actually, there's a compatibility problem in the first place. That's how you get to the creative, interpretative rules that can give you the leverage to achieve those outcomes. So it seems to me that a first premise of some of those who are saying that's the remedy is to actually accept our case. And really, are we not arguing about different methods to really address the problem that we all recognise, that this provision is one that doesn't have proportionality properly baked in? So I think that's where it falls from our perspective. And this, the Kerkurian line of authority, we say, is sound, but and it can be applied in this context. And the attempt to get around that, I think, is one that the court should look at with some caution. So I realise I'm testing the court's patience with time, but I think some of these points I can address in reply. We say the attorney has not brought this reference lightly. I've set out the lawmaking process. I've set out the difficulties that arose in this case. We don't accept that there are high hurdles to overcome in order for a court to address this point. And we say it's entirely legitimate and indeed important for the court and important for the dialogue with devolved legislatures for the court to grapple with the competence question like the one we've raised. And we say the answer is as we've set out in our written case. Well, ultimately, I've probably gone on for too long, and I'll end my submissions there.
Thank you very much, Mr. McGleenan. Well, we'll turn now to the Lord Advocate, and we'll bear in mind, that, Lord Advocate, that you're starting an hour late.
Thank you, my Lord. And my Lord and my Lady, in this submission, the answer to the question referred to this court by the Attorney General is yes. In my submission, there are two issues of principle raised in this case which lead to that answer. In summary, firstly, it cannot be said that in all or almost all cases, Clause 5.2a will be a disproportionate interference with the rights under Articles 9, 10 and or 11, and thus out with legislative competence. And secondly, the duties of public authorities under Section 6 of the Human Rights Act require that safe access zones can only be sought and granted if, not least having regard to the penal provisions applicable to them, the safe access zones would be compatible with convention rights, including Articles 9 through to 11. This summarised position on the issues of principle, which indeed are applicable across the devolved settlements in the UK, will be developed in my submissions. But the underlying question is this. I recognise at the outset that the issues of principle are linked to the underlying question of proportionality of Clause 5.2a, not least because I submit that the bill can operate in a convention-compliant manner dependent upon the particular facts of any given case. And in that regard, Scotland is experiencing similar issues to those in Northern Ireland in connection with protests and vigils outside abortion clinics. These protests have intensified over the last year, with reports of patients and staff being distressed. The Scottish Government convened a summit on the 21st of June of this year and committed to the introduction of legislation, noting that a private member bill is currently being consulted on. It's currently in a draft form. Therefore, I shall also make submissions addressing the proportionality question, in particular, the balance to be struck between the interference with the Article 8 rights of protected persons and the interference with the rights under Articles 9 to 11 of others. In that regard, it is noted that the Attorney General correctly recognises that Clause 5.2a pursues a legitimate aim, namely protecting the rights of others, and captures acts which engage the Article 8 rights of service users attending protected premises. And in that regard, I'd point to the Attorney General's case at paragraph 9 of the core bundle at tab 4, page 28, and the EF number at page 28. Just get that. Is EF number 53. Also, I'd refer to the Attorney General's case at paragraph 47, core bundle, tab 4 at page 40, the EF number for that being, page EF number 38. So there they say at paragraph 40 that the bill is aimed, paragraph 47, page 40. There they say that the bill is aimed at protecting the rights of service users to access certain health services protected by Article 8, and to a lesser degree the rights of those accompanying them and those providing services. And at paragraph 52, the attorney at page EF number 41 also says that they concur with the analysis of the Court of Appeal in Dilguria and accepts that the Article 8 rights of service users are engaged by the acts which are prohibited by Clause 5.2a, and that the clause has a legitimate aim in protecting those rights. So it may be helpful if I start by summarising my position on Article 8 in order to put in context, as the Court of Appeal did in Doguria at paragraph 57, page 567 of tab 6, of the first volume of production of authorities, the interference with rights under Articles 9 through to 11. What I would say is that Article 8 has at its centrality the protection of every individual's right to personal autonomy. And in that respect, I quote again from Doguria at paragraph 57, authorities at tab 6, page 567 of the electronic format. The right to personal autonomy has at its core that everyone has the right to seek counselling and advice from healthcare professionals in order to provide informed consent for medical treatment such as abortion. The information necessary to be able to give informed consent on abortion will include treatment options and material risks of injury, and should be conveyed in a manner that is comprehensible, and a patient should not be bombarded by information. And in that respect, I would refer the court to the authority of Montgomery against Lanarkshire Health Board, which was reported at 2015 Session Cases, Supreme Court, page 63. Montgomery isn't in the bundles that are before the court in electronic format, but I have had the case put before the court, and in particular, I would make reference to paragraphs 82 and 90 of that decision.
Yes, we do have this in our folders for this case as a separate PDF.
Yes, so I needn't then take the court to paragraphs 82 and 90.
I'm sorry, I wasn't meaning to interrupt you. It was just for the benefit of my colleagues.
Oh, thank you. Well, I think it might just help to put in context what I'm saying by looking at paragraph 82 and at paragraph 90, because it is helpful to understand the basis upon which these decisions have been made by service users to these clinics, and the very intense issues that come to the fore when we're dealing with the sort of issues that these young women or older women are dealing with in these very difficult circumstances. So looking at paragraph 82 of Montgomery, there the court explained that in the law of negligence, this approach entails a duty on the part of doctors to take reasonable care to ensure that a patient is aware of material risks of injury that are inherent in treatment. This can be understood within the traditional framework of negligence as a duty of care to avoid exposing a person to a risk of injury which she would otherwise have avoided. But it's also the counterpart of the patient's entitlement to decide whether or not to incur that risk. The existence of that entitlement and the fact that its exercise does not depend exclusively on medical considerations are important. They point to a fundamental distinction between, on the one hand, the doctor's role when considering possible investigatory treatment or options, and on the other, her role in discussing with the patient any recommended treatment and possible alternatives, and the risk of injuries which may be involved. And at paragraph 90, on page 86 of the judgment, it also points out that secondly, the doctor's advisory role involves dialogue, the aim of which is to ensure that the patient understands the seriousness of her condition and the anticipated benefits and risks of the proposed treatment and any reasonable alternatives, so that she is then in a position to make an informed decision. This role will only be performed effectively if the information provided is comprehensible. The doctor's duty is not therefore to fulfilled by bombarding the patient with technical information which she cannot reasonably be expected to grasp, let alone by routinely demanding her signature on a consent form. In this context, it's important to remember that abortion is an intensely personal, private, and emotive matter, and falls within the notion of private life under Article 8. Reference again Doguria at paragraph 53, page 566 of the electronic folder. And there are few greater invasions of personal autonomy and bodily integrity than a woman carrying a pregnancy to term against her will. Again, Doguria at paragraph 54, page 566, citing Baroness Hale in the case of INRI Human Rights Commission for Judicial Review, Northern Ireland abortion, at paragraph 6. That's in the authorities at tab 35 and in the electronic folder at page 1435. The provision of effective access to reliable information as to the conditions for the availability of lawful abortion and the relevant procedures to be followed is directly relevant to the exercise of personal autonomy. The case of Doguria at paragraph 55, page, I think I've checked it, it's 55, page 566 to 567, citing P against Poland at paragraph 111. I should point out that P against Poland is also produced by the interveners, the Human Rights Commission, in their bundle at tab 76, and is referred to paragraph 30, page 68 of their written case. The right of personal autonomy protected under Article 8 extends to the right to attend for elective medical procedure, such as abortion, and having come to an informed decision to undergo that procedure. So having decided to present for an elective medical procedure, the patient can reasonably be taken to have taken an informed decision to have that procedure. It would be inappropriate and indeed unlawful for clinicians to present additional conflicting information once the patient has arrived for treatment. And by parity of reasoning, it is legitimate to protect the patient from those who wish to influence and change the treatment decision that's been made. That is especially so in respect of this most personal, private, and emotive of decisions. If such a patient is protected from being bombarded by information by her clinicians, it is legitimate to protect her from being bombarded by others as she arrives at the clinic, whether that be overtly by way of protest, by placards, shouting, and overt conduct, or by those sitting in silent judgment that can be just as effective as bringing to bear psychological influence. And I'll come on to deal with the question of that sort of protest and whether or not we can indeed categorise it as protest in the way in which Ms McLennan has referred to during his submissions. In my submission, these rights of personal autonomy in this most personal and intimate matter are interfered with by those persons seeking to influence that exercise, both the process of seeking information and advice to arrive at an informed decision and thereafter in proceeding with the decision. The Northern Ireland Assembly was entitled to consider the protection of those personal autonomy rights, a social right, and whether that protection would justify an interference with the rights under Articles 9, 10 and 11. That latter interference should be addressed in the context of itself being an interference with the Article 8 rights of personal autonomy. So in summary, pulling together my observation on the proportionality question in clause 5.2a is not an inherently or necessarily unjustified or unjustifiable interference of rights under Articles 10 to 11. The focus of the Attorney General of Northern Ireland's case being on those rather than Article 9 to protect the Article 8 rights of personal autonomy. So my summary focuses on the woman. Protected persons extend to those accompanying the woman at her invitation and those working in the premises. The interference with the Article 8 rights of those persons, and at least the companion, is of a far lesser degree. That said, the operators of premises will not know the number of patients attending in comparative terms to their companions and employees. Likewise, the protesters will not know, and at least not always know, who is the patient and who is the companion or the employee. The safe access zone is to protect the patient, and that protection includes protecting those who accompany her and who are there to advise and treat her. A friend or relative, a mother or father, a grandparent or sister or brother, as opposed to the pregnant woman, may attend the premises in order to obtain advice for her, for example, leaflets, and they may well fall within the definition of protected person. A restriction on influencing the friend or relative is, I would argue, justified, as it is simply impracticable, if not impossible, to identify in advance who might attend for the purposes of obtaining information. Matters may be different if the premises in question were only there for the provision of advice and information, as opposed to premises where treatment is carried out, as well as the provision of advice and information. The general measure applicable to all three categories of protected persons is justified to protect the personal autonomy of the rights of the pregnant woman. And we know that the pregnant woman can be a child, can be the victim of rape, can be an older woman who is pregnant with her third child, perhaps as a disabled child, and is again carrying a child with fetal abnormalities. There is an enormous range of the vulnerable women who are seeking to access these services, and they are entitled to have their Article 8 rights protected, and the protection afforded to them must be widened to those who accompany such a vulnerable individual in such circumstances as they find themselves. So after that summary of my position on Article 8, can I return to the issues of principle that I referred to in my opening remarks? The first issue of principle is the approach the Supreme Court should take in determining a pre-assent reference. And in my submission, the approach is to ask whether a provision, in this case clause 5.2a, will in all or almost all cases be incompatible with convention rights. If not, the provision cannot be said to be beyond legislative competence in the abstract. In this respect, I would refer the court to the authority of Christian Institute against the Lord Advocate, which is in Authorities tab 2, paragraph 87, and I'll just get the electronic folder number. At page 434, I'm looking at paragraphs 87 and 88. That particular decision. I think we read with Mr. McLennan 87 and 88, and I'm also wishing to refer to the case of R.B.B. against the Secretary of State for the Home Department, authorities at tab 34 at paragraph 2, pages 1403 to 1404 of the electronic folder. And indeed, these particular references are fully set out in our written case. At page 72 of the electronic folder, at paragraphs 12 and 13. And so going to the passage at paragraph 2 in BB, I think it's important which is at page 1403, to look at what Lady Hale said there, because it's very much reflected in what was said in Christian Institute, which is that the appellants argue that the rule is an unjustifiable interference with the right to respect for private and family life protected by Article 8 of the European Convention for the Protection of Human Rights and Fundamental Freedoms, or that it's unjustifiably discriminatory in securing the enjoyment of that right, contrary to Article 14 of the Convention, or that it is irrational and therefore unlawful on common law principles. They have set themselves a difficult task. It may well be possible to show that the application of the rule in an individual case is incompatible with convention rights. It is much harder to show that the rule itself is inevitably unlawful, whether under the Human Rights Act or at common law. In the attorney's written case, at paragraph 22, the Attorney General herself says, the submission for the reasons outlined below explains that the offence as currently set out in the bill could result in a disproportionate interference with convention rights of the potential protesters. So I think that Mr. McLennan took the court to the case of McLaughlin, but I think the authorities of Christian Institute, which refers to our baby, are very clear, and the position really is beyond doubt in terms of the analysis that's provided there, and supports entirely the first issue of principle that I'm relying on in terms of the approach the Supreme Court should take in determining a pre-assent reference.
So can I just be clear, what is your submission? If we were to accept that, does that then preclude our examining the matter at all, or what is the relevance of that principle, the task that this court has to undertake? Is it some knockout blow right from the start? Is that what you're submitting?
It is, yes, it is, because we're not at we're not in a UNCRC case. We're not in the case that Mr. McLennan referred to, which was essentially a legislative competence question. This is not that sort of case. This is very different. The task here is whether or not clause 528 is, or almost always will be, incompatible with convention rights. If that's not the high hurdle, if that high hurdle rather is not passed, the answer to the references, yes, it is within competence. And it might help just to look again a little bit at what the UNCRC case was about. It's at tab 36, page 1539 of the authorities. And without looking at that in detail, at the moment, I think I can summarise what happened in that case. The approach that I'm relying
before
on...
you go there, could I just, before you go there, say we were against you on the proposition you've just put forward, that that very high threshold is not something that your opponent has to overcome, but that the correct text is, as he submitted, the McLaughlin test, that is that the bill must inevitably operate incompatibly in a legally significant number of cases.
Yes.
What would you say about if we were to accept that? Do you say you can't, your case falls apart, or do you say in any event that test would satisfy?
So it would satisfy that test because on an analysis of the provision that I'll come on to deal with later, it's a provision that's clear. It was within the it's proportional. It was within the margin of the area of work of the Northern Ireland Assembly, and it's a provision that doesn't have the consequences that are referred to in the McLaughlin case. It's not a provision that will produce cases which will result in an unlawful outcome. It's not a case where there'll be a number of illegal convictions.
So what I think saying is, ultimately, it doesn't matter for you.
Yeah.
Which actual test one is applying, because you would say you win in any event.
Yeah, I think my fundamental point though is that the McLaughlin case was dealing with something different. The relevant authorities are Christian Institute and BB, but that's why I did spend some time on the Article 8 analysis to place the process of balancing the competing rights in this case in context, which is what the Northern Ireland Assembly did do in bringing about this legislation. So I agree with what you've said, Lord Burrows, that I win on any analysis. So perhaps just dealing with the UNCRC case at this point, my approach doesn't run counter to what the court held in the UNCRC case. The Supreme Court held in that case that it should be possible to determine from the outset whether a provision falls within legislative competence of the Scottish Parliament, and I suppose by extension also the Northern Ireland Assembly, or not. And in that case, the court looked at Section 101 of the Scotland Act and said it wasn't to be used to enable the courts to undertake a rewriting of legislative provisions that were plainly and unambiguously on their face outside legislative competence. Clause 52A, and indeed the bill itself, is not plainly and unambiguously out with legislative competence. In the UNCRC case, at page 1557, it was accepted that the duty under the Act to ensure future compatibility with the UNCRC may relate to a reserved matter, and hence was beyond legislative competence. But that could be addressed by a subsequent court placing a corrective limitation in individual cases to work out if a particular function did in fact relate to a reserved matter. As Lord Reid described it, there was a deliberate excess of legislative competence, which, it was argued by the Lord Advocate in that case, could be corrected in individual cases. But my submission doesn't invite postponement of legislative competence in this case. Rather, I say the legislative competence is properly addressed at this time, having regard to the approach applicable for a legislative competence challenge based on convention rights. Would it always, or almost always, be incompatible with convention rights and to the duties of public authorities under Section 6 of the Human Rights Act? The second issue of principle that I'll come on to deal with. So essentially this reference is different. It raises a different question to that of the UNCRC case, where the impugned provision was clearly relating to a reserved matter, and they attempt to use Section 101 of the Scotland Act to bring that otherwise incompetent provision within legislative competence. As Lord Reid himself noted at page 1559, having discussed the case of DS against Her Majesty's Advocate, the Section 3 Human Rights Act exercise, the court's task was on the interpretation of the legislative text to see if it related or not to a reserved matter. No such task arises in this case. The task here for the court is whether Clause 5.2 is, or almost always is, incompatible with Convention rights. So applying then the all or almost all approach to this reference, I would say this: the bill sets up a framework for the establishment of safe access zones and associated penalty provisions prohibiting certain conduct, including Clause 5.2a. The operator of the relevant premises must request the establishment of the safe access zone. As the Attorney General notes in her case at in the core bundle at tab 4, page 30, paragraph 16, most operators will be public authorities for the purposes of the Human Rights Act, Section 6, and so they must act compatibly with Convention rights in coming to a decision to notify a wish to be protected premises. The Attorney General also further noted at paragraph 22 of her written submission at pages 31 through to 32, Clause 5.2a could result in a disproportionate interference. In other words, it is not an inevitable interference. So in order to act compatibly with the Section 6 Human Rights Act duty, public authorities could only lawfully request a safe access zone with attendant penalties if that was justified in particular circumstances. The public authorities would require to assess the proportionality of any interference with rights under Articles 9, 10 and 11, balanced against the Article 8 personal autonomy rights, in order for the safe access zone to be justified. That being the case, the bill and the clause 5.2a, should and could in principle at least only be operated in a manner which is compatible with Convention rights, and any interference with rights under Articles 9, 10 and 11 would require to be justified in order to comply with Section 6 of the Human Rights Act duty incumbent upon authorities, which in most cases will be the relevant operator. To bring this to a close, I see it's just after 4 o'clock. In other words, I would say this: it's just not possible to conclude that Clause 5.2a is inevitably unlawful under the Human Rights Act, because it may be required to protect against an unjustified interference with the personal autonomy of women. And so I wonder if this is an appropriate point to stop for today, Lord Reid.
Yes, if that's convenient for you, Lord Advocate, then by all means. I've had no notification that the engineers have managed to sort out the air conditioning. So unless you hear otherwise, we can presume we'll be sitting in the same format tomorrow. We've obviously lost a good deal of time today. We may or may not make up time tomorrow, but in the event that we don't, are people in a position to sit after lunch if we need to complete the hearing then? It looks as if people generally are able to. Good. Right, I'm not encouraging that, but it may prove necessary. Very well. In that case, for no other matters, we'll adjourn for the day and resume at 10:30 tomorrow. Thank you very much.